Justice of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business before this court, draw near to the attendants, and they shall be heard.
Thank you. Please be seated. First case on our calendar today for oral argument is 897, People versus Latone. 897. Good morning.
Good morning. May it please the court, Brad Keem for Tanya Latone. We contend the guilty plea was invalid. In regard to preservation, it was impractical for Ms. Latone to move to withdraw her plea, considering the plea and sentencing occurred at the same time. Then, on the merits, the allocution really didn't have a confirmation that she understood the nature and consequences of the plea. It looks like something's missing from this transcript. Either the court reporter didn't start transcribing. You can see the clues. There's 3 clues. The first is the
Can I just interrupt? What do you suspect that your client didn't know when she pled guilty? What information was missing?
I think there's no indication at all on this record as what the years are, what post-release, what anything in the beginning is in terms of what's the deal? What are we dealing with?
Judge Van Allen, before the plea was entered, not at the outset of the proceeding, but before accepting the plea, did say, this is what you're getting. You're getting this sentence, is going to be concurrent to this, so forth and so on. That occurred before her plea, but not at the outset of the proceeding.
Right, and I think that at the outset of the proceedings, though, is where she makes these claims, where she says that trial court said you need to talk to defense counsel just as you did a moment ago. So a moment ago, there was some kind of conversation between appellant and defense counsel. Okay, we don't know what that was about the nature of the plea, because we've all read thousands of these. They start with the court or the counsel or the prosecutor saying what the deal is, and this one did not have it, but what it did have was appellant being confused and something on this record occurring. I think we can all agree that something occurred on this record before it was transcribed.
I think there's, good.
I'm looking at pages 6 to 8 of the plea transcript, and there the court recounts what the deal is at page 6, and then there was an allocution where your client said guilty, guilty to the allocution both times. So that's what the deal is, and the admission of guilt to the particulars of the allegations in the indictment are all together. I'm sorry, Mr. Keem, I'm having a little trouble following why that's not enough.
So it's not enough because of what occurred before then. And I think it's clear that something occurred before then. There's the moment, too, where the trial court appellant said that she heard everything so far. So far on page 2 of the transcript.
Right, look, it looks like there's a transcript missing from the record.
Yes.
And we understand your point, that there may be, she might have been confused about something. We don't know that, you don't know that. You don't know if she misunderstood something, but you think it should be remitted so she should, so the court could explore that.
Yes, I do.
All right, thank you very much.
Good morning. Josh Tonner on behalf of the people. I think that the arguments that are raised by defense counsel underscore the need for preservation in this case by way of a 440 motion. If there's anything that the defendant didn't understand or was unclear from the record before it, to raise that by way of a 440 motion would have been the appropriate method to do it, because everything else that's within the transcript indicates the defendant's understanding. There was never a point where she appeared confused. There was never a point where, despite being given an adequate opportunity to speak with counsel, if she needed to ask any questions of the court, she confirmed her understanding of the plea agreement, the nature of the rights that she was giving up, and also, both she and defense counsel confirmed that this was the plea agreement that she was accepting.
Thank you, counsel.
Thank you.
Case 881, People versus Hector Rojas Aponte.
Good morning again. I'm appearing off counsel to Ian Rennie in this matter. We assert that appellant's constitutional speedy trial rights were violated, and Justice Lindley and Courtroom, we had a really good discussion similar to this on Stefanovic, and I didn't convince you then. I got Justice Nemoyer, but I'm hoping that in light of Reagan, this court will find differently.
The one difference is it was preserved in Stefanovic, right? It's what's not preserved here.
It is not preserved here.
But I will acknowledge, things got better for you since Stefanovic in light of Reagan from the Court of Appeals.
Correct.
Reagan's a tight standard.
It is.
I don't know, this one, so you got a legitimate argument if it were preserved. You got to get over that hurdle.
Right, and we would ask that the court look at it not only in the interest of justice, but appellant shouldn't be penalized for defense counsel's error, so it could look at it through an ineffective assistance of counsel lens, because counsel did a lot of things right, but some serious things wrong. But back to the case, the court, I'm sure, is aware that the Court of Appeals, the chronic lackadaisical approach to reports of sexual assaults by prosecutors and police, that language, it fits the bill here. You have a report in 2016, and it languishes until April of 2019. Appellant's finally arrested in October of 2020. So I think it's clear that the extent of the delay is to the defendant. The reason for the delay, when I read this, I'm like, how is this possible? The Olson said they dropped the ball. We can't accept this anymore. That speaks to the defendant. Nature of the charge, it's a severe crime, but it's not complex, okay? Maybe that's a toss-up. We have incarceration, some that's COVID-related, that can go to the people. In 5, impairment, we have memories, alibi potential, DNA potential. Even if the court doesn't go along with that factor completely, prejudice is not required, okay?
But your argument, in a nutshell, is that this is even more favorable for the defense than Reagan. And the Court of Appeals reversed and dismissed the indictment of Reagan due to the delay there. Could you move on to the discovery issue with respect to the disciplinary records? The district attorney in Onondaga County apparently has a policy for the disciplinary records, personnel records. They're screened by a group of senior prosecutors, and they determine what to turn over and what not to turn over to the defense. That's being challenged here. Do you wish to be heard on that issue?
Yes, so I recognize the court's decision in Johnson where it said that police disciplinary information has to be provided only to the extent that it's related to the subject matter of the case. But the problem here is the senior level district attorneys, not even the attorney preparing the case. It's problematic on so many different levels because the best judge of impeachment value of evidence is defense counsel, the single-minded, zealous representation of defense counsel.
Can I, and in Johnson, it's distinguishable is that we knew in Johnson, I was on Johnson, we knew what the records at issue were. Here, we have no idea, nor do you, because they weren't turned over. Do you agree there was one police officer witness in this case? Are you arguing that her disciplinary, we're just limited to her disciplinary records? Is that what we're talking about, not any other officers?
Correct.
Okay, so her disciplinary records. Do you know if any disciplinary records were turned over with respect to the testifying detective?
No, we have no.
Do you know if any were withheld?
No, we don't know anything.
So, nor do we. And that's the problem with this policy is that, well, you would know if something was turned over.
Right, I suppose that's true. We would know.
But you don't know in this case if anything was turned over?
No.
Well, the prosecutor signs the certificate of compliance pursuant to the statute. I've got it here somewhere, which you know the language, in good faith,
Yes.
etc. And they certify this, and then there's the attached index to the certificate of compliance, and subparagraph K is the pertinent one. The prosecutor labeled it Brady and Giglio, whatever it is, and they don't identify anything there that they have.
Correct.
So on this record, isn't it fair to conclude that there were no such personnel/disciplinary records for the particular officer testifying? What else do we have?
I don't know if you can make that conclusion because we don't know. It's an inference. It's not definitive. And I think that the statute demands more than that.
Wasn't it similar to like a Brady situation where the prosecution then sifts through and turns over what's relevant in those situations as well? I mean, we trust the DAs and prosecutors to make that evaluation.
I think that we can when it's the prosecutor that's involved in the specific case. But here we have multiple steps that are very strange. Why is a senior group of ADAs looking at it I know there's more cases like this that are coming, and in others, the attorney that's sitting talking to the court has no idea what is happening with these disciplinary records. This is a flawed policy.
Well, but that policy really isn't before us because we don't know if anything was withheld.
Right.
And so that's really where I'm stuck on, Mr. Keem, is that, I mean, if there's a good faith certification that one could, I think, legitimately infer, there's nothing. Like in the Rouse case, there was that separate lawsuit that was going on, as I recall.
Correct.
So the defense was able to say, hey, there is stuff. Now here, we don't have any of that. There is some suggestion, maybe in counsel's affidavit there was some, but I didn't see anything specific. So, I mean, this is going to keep percolating, right, until some court somewhere at an appellate level says, this is not right.
Right.
But maybe, I'm not sure I'm right on this, but, you know, Brady's the closest analogy, I get that. But here it's automatic discovery, is what the legislator says. You have to give it over no matter what. And if you withhold anything, you got to seek a protective order, correct?
Correct, and they have the opportunity to do that and didn't do it.
But if they had nothing, they
Right.
have no reason to move for protective.
And
order.
again, I suppose that's another inference to assume that there is nothing, but again, it's dangerous and it's contrary to the heart of the statute.
Well, you're assuming that there's something there.
Of course.
Right, and you don't know, but the reason you don't know is it's a direct result of this policy from district attorney's office. They don't tell you what they don't give you.
Exactly.
How are you supposed to know? We're in the dark because of this policy.
Correct.
Well, it's just as Kearns indicated, that you got the certificate of compliance, which indicates that basically the attorneys are swearing that there's nothing there.
Yeah,
And again, you're not taking that for granted.
No, of course, and with all respect, I completely understand that this case may not I would encourage the court not to take a definitive stance on this, because I think there are other cases that are coming on the pike that are going to be more, the court will be able to make
What would be the harm here? Because look, they say there's nothing there. That's what the DA say. But we don't know if that means there's no records at all or there's nothing that we feel is impeachment material. What would be the harm in remitting to county court and having a more full record developed where what exactly are the records for this one officer? What's the file look like? What did that group of DAs, did they screen anything? Maybe there's no records at all, in which case there's no basis for reversal. Maybe there's one record and it was turned over, no basis for reversal. Maybe there's 3 records, none were turned over, then perhaps that may be a reversal, or we have to look at the nature of those records. If it was totally unrelated and there was no impeachment value, then there's probably not a reversal. So the bottom line is we can't really tell what happened here on this record.
Well, and that would be an eminently reasonable compromise position for a case like this, where we can't tell.
Mr. Keem, how do you get around the requirement in the statute that all items of information relate to the subject matter of the case? I mean, there may not be something in her records, if anything, that are related to the subject matter of the case. That's what the statute says.
It may not, but why not, as Justice Lindley, I think, that why not remit
So
it
basically,
and
you'll
find out?
challenge every single certificate of compliance.
With this kind of policy, I think that it's necessary. I think that this policy is flawed in accordance to the
And I
statute,
think
respectfully.
what your argument is, if I understand your brief correctly, is you have to turn over under 245-20 information and evidence relevant to the case, okay? There's another provision later on in that same statute, under K4, which talks about you have to turn over impeachment material for any testifying prosecution witness. So you can have impeachment material that's unrelated to the case. It could be he committed perjury in another case. That would be discoverable in your view, even though it's not the subject matter of this case.
Right,
Impeachment is always relevant in your view.
absolutely.
All right.
Mr. King, and this is a loaded question, I'll confess that to you.
Okay.
But as I read your brief, and I think your argument is that in the first instance, the defendant was entitled to all personnel records, and then it was later narrowed to law enforcement disciplinary records, that you're entitled to all of them at first blush. That is, give it to us. You're not supposed to make the decision, DAs, as to what we get. Give it to us. And I think you're bound by that argument, is how I read it, because we have nothing from the electronic portal that was provided to defense counsel showing that anything was withheld or produced. So the long story short here, my long question is it fair to interpret your argument here as bound by the record that you get everything in the first instance? Is that your argument?
It is my argument, but I also am willing, I understand that if the court wants to fashion it in a different way, because I can see what Justice Montour's points are as well. I hope that's an approach.
You asked for everything, and there are, by the way, a number
Of lower
very
court,
number,
yes.
a large number of trial judges who have said just that.
Absolutely.
Very few trial judges, if any, have gone the other way. The state of the law at the miscellaneous level is you turn over everything, the defense can figure out, because there's no confidentiality anymore. 50A has been repealed. So nothing is under seal, nothing. So the trial judges that you rely on and others have said, turn over everything. Now, it doesn't mean we have to follow that, but I guess that's your first argument.
That's my
But
first
we
argument.
don't know if they turned over everything or not. 'Cause
Correct.
maybe there's nothing to turn over.
And that's where the remittal comes in. I just don't want the court to say no automatically on this. I think we need to take it by steps.
I might respectfully disagree with my learned colleague with
That's allowed.
respect to the breadth. And I'm not sure where I come out on this, but we've got the FOIL cases that I was on for the Syracuse Police Department and the Rochester Police Department, and took a hard look at the elimination of 50A. I don't know that you get all personnel records. That was your demand in this case, personnel records. Really? That's what you get? All of that? I don't think so, as impeachment. So I don't think it's that broad. You don't get all that. Then the question is, what's in the personnel records, does it constitute law enforcement disciplinary records? One way to read that statute is you get law enforcement disciplinary records if there's been a complaint filed, and then anything that happens thereafter as part of the disciplinary process can be viewed. But there's a whole other segment that might not be in the pipeline that you don't get. So without that definition, I'm not sure we have a good enough record to even remit. But what do you think about that?
I think the record is sufficient to remit.
Thought you might.
Given my loaded question, I wanted to give you that.
Yeah,
Be a loaded answer.
We understand your argument. Thank you very much.
thank you.
Good morning, Elizabeth Dannon for the People. Should I begin with
Well,
the,
Regan's a tough case for you, is it not?
actually, I do believe that the case is very different from Regan here. In Regan, there was DNA evidence that was turned over the day of the crime. It was an adult victim. There was no problem with delayed disclosure in that case. And a police investigation commenced. It was the prosecutor that unexcusably delayed for months on end with no explanation. Here, while there was a disclosure of abuse in 2016 to the Syracuse Police Department, that Syracuse Police Department, a very small division, the APU, had twice before had the same complaints, with the same victims, same abuser, had conducted investigations and had been foreclosed by the parent of the victims. And we would state that the circumstances are very different. I hope the court has seen the 2019 Child Victims Act. The rationale for that there is that child victims often disclose very late. And according to Child Sex Abuse Accommodation Syndrome, the disclosures can be conflicting, can be unconvincing. And in this case, there were two prior disclosures to the 2019 one that was finally pursued that were actively refuted by the defendant and his accomplice. So that gives a good reason for the delay here. It was not any DNA evidence. There was a need to conduct an investigation. The facts were not as clear-cut. There had to be an investigation into many witnesses. There was a lot of photographs taken. So we would contest that Regan is applicable in this situation.
On the discovery issue, do you know whether any disciplinary records for the testifying police detective were withheld by this group of senior prosecutors? And do you know if any were turned over?
Your Honor, from my reading of the record, there are none, and none were turned over. And honestly, from my own personal curiosity, I did look, and I was not able to find any. However, if Your Honor believes that this should be remitted for a fuller,
You're saying outside the record, we're going to veer outside the record a little bit here. You're saying there are no disciplinary records for the one testifying officer.
not that I
So
was
nothing
able,
could have been screened because nothing exists.
to my understanding,
But
Your Honor.
if that's the case, a remittal, you're fine with it because it will just prove what you're saying.
Yes, Your Honor.
Do you, this policy, this is ongoing policy where the DAs determine what is impeachment and what's not? That's continuing in the Onondaga County DA's office?
I have not determined what is our latest policy. I did read a memo that was a couple of years ago about the policy of not turning everything over. I guess there are, the concerns that I did write in my brief about was that there could be, rabbit holes. A lot of people make frivolous complaints, and we could, a trial could be turned into a just chasing down.
Correct, and there's going to be a lot of stuff, depending if there's a distinction between personnel file and disciplinary, there's going to be a lot of stuff in there. Somebody gets disciplined for showing up late for work. But the problem with this, the potential problem with the policy as it exists is that the defense and the trial judge and the appellate court are in the dark as to what was withheld. And I understand, it sounds like at the beginning of this policy, your office dumped everything on the trial court and said, here's all the stuff, you figure out what should be turned over. The trial judges wanted no part of that. They said, no, thank you, we're good. Then the DA just said, we'll do it ourselves. And this is where we are now. It may not be a problem in this case if nothing was withheld, but if something is withheld, it's the defendant, you see the problem, the defendant needs to be able to challenge that, and the court needs to be able to determine whether the prosecutors properly screen the impeachment material.
Yes, Your Honor.
And under the current policy, that's not possible. It's just, we trust you guys. You guys earned our trust, and we'll just take your word for it that you separated what should be turned over and what shouldn't. That doesn't sound like I'm not sure the Court of Appeals is going to be in love with that policy.
Yes, Your Honor.
But over to Justice Montour's point too, if we do an analogy to Brady at all, I mean, Brady sometimes, we don't have any Brady. That's
Yes.
what, okay, but then later on, the defendant finds, yeah, you did have Brady, there was this, that, and the other thing. Is this any different than that situation? That is, when you sign that certificate of compliance, whoever signs it, they've made diligent efforts, et cetera, good faith, that's a big signature. It better be right. Is this different based on automatic disclosure from Brady?
I believe it is different from Brady in that I believe for Brady you have to prove that there was some form of prejudice that resulted in. For the automatic disclosure, I do not believe there has to be a showing of prejudice from the withholding. Is that, I believe.
But his point is that, and Brady, the prosecutors, we're trusting the prosecutors, that they're going to turn over exculpatory information, and we don't know if they don't, unless somehow it gets found out. But I would suggest a difference between Brady and discovery is there's a defined universe of discovery, of disciplinary records. There's a file that contains, we have one officer here, there's a file in the disciplinary records. Each police department is a little different, but that's a defined universe. And what the defense bar is saying, and some trial judges agree, whether we agree with that or not, is just turn over everything in that file. We'll decide what is valid impeachment. You can move to protect for an order to protect some of the documents if you wish. The trial judge can say, no, you can't impeach on that, that's irrelevant. But with Brady, there's no, Brady material is defined, but all the other stuff you can't turn over non-Brady because it would be unlimited, so it's just not feasible. But there is a limited universe of these disciplinary records. And again, it's nothing is, like what would be the harm in turning over all the disciplinary records on a police officer? These are records that now can be foiled, can be accessed. The city of Rochester puts them up online, publicly available anyways. So why not, if it's not prejudicial to the police officers, it doesn't go to impeachment, just turn it over and then it is not a good enough answer to say, well, you could just foil it yourself because it burns on the prosecution. Foil, you know how that, you put an application in and it gets delayed and it'll never be in time. The legislature says the obligation, it's automatic, you got to turn that stuff over. So, but this is an interesting one. Anything further on the discovery you wish to add?
No, Your Honor.
All right, thank you very much.
Thank you.
883 is People versus Michael Gandy. I'm sorry, James Taylor. We'll do James Taylor. 882, James Taylor. You are here for Mr. Taylor?
Yes. Good
And the
morning, Your
people conceded, and they're apparently resting on their concession. Do you wish to
Yes.
add anything to their concession?
No, I was just here to ask that this court reverses conviction, suppress the evidence, and dismiss the indictment against him.
Don't we have a bit of a Concepcion problem here, though, in terms of dismissal? The court really didn't address this prong of divorce.
That is correct, but as the people put in their brief, based on, I don't think it's based on Johnson. I think the result would have been the same with or without Johnson. That was just decided. The evidence will be suppressed if it goes back, so it's sort of futile to send it back just to have it suppressed when this court could just
So we
suppress it.
ignore Concepcion in the interest of judicial economy or something like
Yes.
that. I didn't know we could do that, but I got to think about it.
If the court has no other questions, I'll rest on my papers.
Thank you.
Thank you.
883. That's a good point. 883 is Gandy, People versus Michael Gandy.
Good morning, Your Honors. May it please the Court, Susan Hutchison on behalf of the appellant Michael Gandy. I will be discussing points 1 and 2 of my brief. The appeal waiver here is invalid because the trial court misinformed Mr. Gandy as to its scope. The trial court informed Mr. Gandy that he was waiving his appellate rights to have any mistake or error reviewed. And for this reason alone, that should invalidate the waiver. In addition, the trial court failed to confirm on the record that Mr. Gandy had any comprehension or understanding of this purported waiver.
How about the merits of your issue?
Thank you, Your Honor. With respect to point 2, the photo array here under the totality of the circumstances was unduly suggestive. There were not only lighting differences, but the fact that Mr. Gandy was the only individual wearing a red-colored shirt.
Was the red, I would agree with you if the witness had described the suspect as wearing a red T-shirt. I didn't see that being the case here, though.
That is correct, Your Honor. There's no description that he was wearing a red T-shirt. However, in the photo array, he was the only individual wearing a red shirt. And with the lighting differences and the witness's uncertainty, it's our position that under the totality of the circumstances, it was unduly suggestive and led a person to view number 6 as the likely suspect.
Okay,
How does this, I'm sorry, how does this case differ from People versus Lacrosse, where it happened to be a red shirt as well in that case, coincidentally, but the standard being that it's not so distinctive as to be conspicuous? Why in this case would it be conspicuous? It looks like from the photo array that we have that there really is very little of the shirt even showing in the photo.
Yes, I actually looked at the photo array in People via Lacrosse. It was attached to the DA's brief. And that photo array, all of the photos were of very similar lighting. They all had a light blue background. All of the facial illuminations were exactly identical. The only difference was, in that case, the suspect, Mr. Lacrosse, was wearing an orangey red shirt, and this court found that that was not unduly suggestive. In my case, not only is Mr. Gandy wearing a red shirt, but there are dramatic lighting differences.
Your argument is you got red and you got dark color combined. Lacrosse is red. The Evans case is lighting alone, not with red. You combine them together. But you would acknowledge the physical characteristics of the 6 gentlemen depicted are quite similar.
I would, Your Honor.
Thank you.
If there's nothing else, thank you.
Good morning, Your Honors, and may it please the Court. Daniel Maddle appearing on behalf of the people in this matter. As outlined in the people's brief, the people's position is that the points 2 and 3 raised by the defendant in this matter are covered by the effective waiver of appeal. If Your Honors take notice of the transcripts, the trial court did specifically instruct or inform the defendant that certain appellate issues do survive the waiver of appeal, and the people believe that that makes the overall waiver knowing and effective. And briefly in regard to the photo array issue, if this court does grant review of that issue, the people would note that while there was different lighting and background shades in the 6 individuals in the photo array, none of them are distinctive from itself. So the photo array background of the picturing the defendant is similar or the same as other photos, as other individuals in the photo array, as well as the color shirts of the other individuals. It's not just all one and then defendant in the red. They're all varying degrees of gray. Unless the court has any questions, thank you.
885 is People versus Tommy Hall. I'm sorry. 884, Dontavius Howard. Thank you. Dontavius Howard. That's right.
Good morning, Your Honors. Clea Weiss on behalf of Mr. Howard. An attorney's violation of ethical rules when their client is the victim of those ethical lapses can constitute ineffective assistance of counsel. In this case, counsel disclosed confidential information to the trial court, and that information was detrimental to his client. I filed as an additional citation on Monday the Rules of Professional Conduct, Rule 1.6, which defines confidential information both as attorney-client privileged information, but also, quote, information likely to be detrimental to the client if disclosed. And what's really notable about this case to me is there's not one off comment or a single disclosure. At almost every court appearance, there are repeated disclosures of confidential information. One of the strongest examples here of detrimental information happens after jury selection. Without any prompting, defense counsel tells the court he wants to make a record, and he proceeds to tell the court, quoting, that his client is annoying and irritating. This is the tribunal that's going to be sentencing his client if there's a conviction at trial, and then he proceeds to detail all of the ways in which his client is being annoying. The court ultimately had to step in to act as an intermediary between defense counsel and the client. There's other examples of detrimental information that counsel discloses to the trial court. On November 13th, 2018, he tells the trial court that finding a trial strategy for this case was extremely difficult. Not exactly the hand you want to represent to the tribunal in which you're about to have a jury trial, or the client could have elected to have a bench trial at that juncture. There's also more classic confidential information, attorney-client privileged information that was disclosed by counsel. So one of the examples is that Mr. Howard wanted to call witnesses at trial, and defense counsel not only discloses that to the trial court, but he also disparages that desire to call witnesses. And again, we see the trial court stepping in to act as an intermediary to advise Mr. Howard on sometimes why calling witnesses might not be advantageous. That's not really the role that the trial court should be acting in, but it happened because defense counsel disclosed strategy and disclosed attorney-client privilege information. And as I said in this case, the disclosures continue. During trial, there's more discussion about witnesses and more discussion about trial strategy. On pages 316 to 319 of the trial minutes, there's an extended conversation between the trial court, Mr. Howard, and defense counsel about strategy. Again, this is privileged attorney-client information. This is not a conversation you have in open court. One last example I'd like to give of these disclosures has to do with the discussion in which defense counsel tells the judge that his client is attempting to retain a private attorney. And the judge is inquiring into this. And through the conversations, not only is the efforts to hire an attorney discussed, but that attorney apparently told the client that he should take a plea instead of going to trial. And there's this debate about why that private attorney declined to take the case. So these are, in my opinion, very egregious disclosures of confidential information, and I think that under Baldy's meaningful representation standard, committing these ethical violations where you're disclosing confidential information and privileged information to the court repeatedly before trial and during trial means that Mr. Howard was not receiving effective representation.
I was uncomfortable reading the transcript in that it seemed like defense counsel was trying to defend himself to the judge against complaints made by the client. It was a difficult client.
No doubt it was a difficult
Very
client who made
client.
complaints
And
about counsel.
The defense counsel was trying to defend himself and say, look, his anger at me is unjustified. I'm doing all these things. What he wants me to do makes no sense. I'm not sure that's in his client's best interest to be doing that to the trier of fact, potential trier of fact, and the person who's going to sentence him. So there were some troubling things there, but we have to look at his performance as a whole.
I agree, Your Honor, and exactly to that point, the people point out in their brief, under that Baldy standard, we look at representation as a whole. One of the examples they give is that he filed appropriate pretrial motions, but I think we really need to dig into this record. On page 18 of the brief is where they say that. But if you look at the omnibus motion on pages 37 to 39 of the appendix, counsel's included information about suppressing things recovered from a search warrant. Okay, well now turn to the transcript from October 16th, 2018. County court's confused. He's like, oh, your search warrant wasn't attached to the motion. And counsel states, oh, there is no search warrant. I just include that in all my motions. So unless this court is prepared to call copying and pasting boilerplate language into omnibus motions appropriate pretrial motion practice, we don't have that to fall back on as otherwise meaningful representation. And just a couple other quick examples of the lack, we haven't even talked about the problems during the trial itself, but on pages 308 to 309 of the trial transcript, the attorney gets up and starts, objecting to things that he's not received in discovery. And he's quickly proven wrong by the people that, oh yes, he has received those items in discovery. And a third quick example, in his closing, he's referencing the wrong kind of order of protection. He's referencing a stay away. He calls it he has to stay away from a house. This is a no offensive contact order of protection. And in a burglary case, an aggravated criminal contempt, that's an incredibly important distinction to be making. So we've just seen examples, little examples throughout the proceedings, both during motion practice and at the trial, where this attorney doesn't really seem to have a handle on what's going on. So combining those small facts, the ethical violations, I'd like to turn to the trial performance, which is also very troubling. You've got an opening statement here. I won't read it to you, Your Honors, but it reads like a closing statement. There's some really, any objection to that would have had the trial court remind the jury that this is an opening statement, this is not argument, would have reprimanded the prosecutor and told them to stay on track and talk about just the evidence that was going to be presented at trial. So we've got a failure to object to a really inappropriate opening statement. You've got eliciting bad information on cross-examination. There's many examples given in the brief. I just want to highlight one example. Defense counsel is cross-examining the victim's sister, and she testifies that if Mr. Howard wants to visit his child, she has to talk to him, that that's part of a custody arrangement. And defense counsel on cross-examination asks this open-ended question, and why is that? To which the sister elaborates, because the nurses who take care of the child are scared of him, and that they have had episodes prior to this one. So defense counsel is essentially eliciting unnoticed Molyneux evidence that there's been prior violent episodes, and that the nurses who take care of the son, this is a child who has 24-hour nursing care in the house, are scared of him. So counsel's eliciting this testimony. Not only does he elicit it, but he fails to ask for it to be stricken. So that's basically unnoticed Molyneux.
Look, if something comes out you don't want out, and you start drawing the jury's attention to it, there might be a legitimate strategy just to let it alone at that point. But your time's running short. I think you probably want to touch on the order of protection. You didn't move to redact that. Is that where you're going next?
So that's kind of a third category of serious trial mistakes that are also happening in this. There's 2 episodes in which counsel allows the jury to see information that indicate that Mr. Howard has prior convictions. One of it is when he elicits testimony from the nurse that Mr. Howard had been released from jail at a previous time, giving the jury an inference that he had been arrested and jailed at a previous time, and then failure to ask that the order of protection be redacted.
Right.
It makes reference to a
crime. On that issue, you're suggesting it should have just been blacked out, just been crossed out, but it's an order of protection. It's signed by a judge. The jury's going to know the man was in court, and he was ordered to refrain from offensive contact against the woman. It was a misdemeanor. It said it was a criminal mischief or something. Isn't it possible that defense lawyer may have looked at that and said the jury might think it's something a lot worse than a Class A misdemeanor, so I'd rather have them know it was criminal mischief rather than some violent crime. And again, it's not like with the other thing about you just got out of jail. They're going to know. When you have an order of protection signed by a judge, you're in court for doing something wrong. So it's not as though they wouldn't have had any idea of his prior criminal past.
I see what you're saying, Justice Lindley, but I think that on this record, imputing any strategy to defense counsel's decisions is a stretch. This is a record that is littered with ethical violations, extremely poor trial strategy, and little mistakes also along the way. So yes, you could theoretically think of a strategy to support that one omission.
You're not
that
willing
is one
to give
of
him
many
the
omissions.
benefit of, you're not willing to give him the idea that he might have come up with that on his own, given his litany of other mistakes that have been made.
I'm not, and I also think that this court can take judicial notice that this attorney has been the subject of prior findings of ineffective assistance of counsel, and I think that that is a lens through which his performance in this case should also be seen.
Thank you, Counsel.
Thank you, Your Honors.
Good morning, Your Honors. Lisa Gray on behalf of the people. I think it's really important to note that in this particular case, trial counsel had the uphill battle of representing a particularly difficult client against a particularly difficult case in which the people's proof was extremely persuasive, extremely overwhelming. The record just shows that Mr. Howard was combative. He was disruptive. He took issue with almost every single person who came across him from start to finish in this entire case, including his own counsel, including the judge, and counsel, to his credit, did everything that he was supposed to do. He filed appropriate pretrial motions. Now, whether or not appellant counsel agrees with that or not, motions were filed, a hearing was held, counsel pursued some defenses in terms of his mental health history that might have played out at trial. He was unsuccessful in that pursuit, of course.
How about the comments to the court where Mr. Moranti, I think it was, the defendant had talked to another lawyer, Mr. Moranti, and Mr. Vaca here, his lawyer, said, yeah, Mr. Moranti told him to go plead guilty. How is that justified?
I don't necessarily think that's any sort of breach of any sort of attorney confidentiality agreement by any means. It's a conversation between two attorneys. And also, don't forget, it's in the context of Mr.
What
Howard.
strategy could there be for that? I mean, the message is, yeah, he went to see Mr. Moranti, oh my goodness, you should plead guilty. Like, there's so much evidence against you. That doesn't seem to be terribly helpful to the cause.
Maybe it was a comment better left unsaid, but again, it was in the context of, you know, Mr. Howard, what do you want? What do you want to have happen in this case with your attorney? And Mr. Howard could never put a fine point on it. He couldn't particularly articulate what it was that that his counsel was doing wrong. So with respect to, yeah, those particular comments, again, better left unsaid perhaps to the court, but certainly not ineffective.
Right, the problem is we have a lot of those better left unsaid comments here. It's like how many better left unsaid comments, when they pile up, equals ineffective?
I mean, respectfully, I don't necessarily think that's the case, because sort of, Justice Lindley, what you're saying before, I mean, I suppose trial counsel could have gone to great effort in trying to cure whatever evidence that might have been elicited on cross-examination, or gone to efforts to redact the order of protection. But again, at some point, you go through so many efforts to try to cover up things, but all you do is end up drawing more attention to something. So all of these instances that appellant counsel points to certainly are supported by strategy on the part of defense counsel.
But with respect to cross-examination, for example, just to take one of the points, if you enter a cross-examination as a general rule or as a practice of basically having a rehash of a direct examination, where you ask lots of open-ended questions again, and you do that with every witness, I mean, don't you open that door up over and over and over again, so that, you know, then later to say, well, gee, I didn't want to draw attention to it. Well, it's kind of the way you do things, and isn't that something that we should be concerned with?
I think traditionally, yes, right? Cross-examination is yes or no answers. You know, obviously open-ended questions are reserved for direct examination. So counsel's approach to cross-examination was perhaps a little counterintuitive, but I believe that what it shows is that counsel had one tiny foothold into the people's proof, which was this idea of he did not intend to commit any crime when he entered that house. It was just solely to see his son. So the way he crafted his cross-examination was to sort of draw out that information that he had been to the house before. On its face, maybe entering the window was a little odd, but that's just sort of how he would approach the house, and the nurse might let him in sometimes, or she'd go get the ex-wife to come and let him in the house. So again, yes, I mean, his cross-examination tended to elicit information due to his open-ended questions. But I do think the strategy behind that was to illustrate that his entry into that residence wasn't to commit a crime. It was just to really just go see his son, and that's generally how he entered the house.
The fact that counsel apparently didn't understand the nature of the order of protection, should that trouble us? He thought it was a stay away and it wasn't?
When I read that, my interpretation of that was that the counsel didn't misunderstand the nature of the order of protection. When counsel referenced staying away, it was to stay away from, assaultive or harassing behavior with respect to that individual. It wasn't to stay away from the building or the resident. It was to refrain from. And I think he colloquially referred to it as just staying away. But I think what he meant was to refrain from the behavior.
Staying away from beating her.
Correct.
Yeah, look, we understand the evidence here. It was a tough task for any lawyer. I'm not sure Perry Mason would have pulled this one off, but we don't have harmless error on this for ineffective. So we got to take a look at all these alleged deficiencies and look at his representation as a whole and see if it meets the Baldy standard.
Correct, and I guess I'm not suggesting that harmless error does apply. It's just the fact that it's the context of the case, and everything that counsel did was based in strategy, and it was in response to the context in which he was zealously representing his clients. And just briefly with respect to the opening statement, Your Honors, I would just note that the prosecutor did set forth the nature of the charges. She briefly went through the evidence that she anticipated would come out during the trial.
I don't think I've seen an opening where you don't at least identify the crimes the person's being charged with. That was a bit odd.
I think actually that goes to support the fact that he was quite effective. Honestly, I don't think I've never seen an appeal where somebody actually preserves that particular issue. So I thought that certainly was a good catch on defense counsel's part. It was certainly a colorable claim. I'm certainly not conceding it on appeal. And I think the prosecutor maybe did go a little off script. Generally, you see sort of a cold recitation of the indictment. But in this case, this was a fairly dramatic set of facts. And I think to the prosecutor's credit, I think she was trying to give context and bring life to the jury, just the nature truly of what these charges were.
Thank you.
Thank you.
885 Tommy Hall, People versus Tommy Hall.
Good morning again. Clea Weiss on behalf of Mr. Hall. Because the people concede that the waiver of appeal is invalid, I would move straight to the merits of this case unless the court had any questions regarding the waiver of appeal. So I'm going to focus on the youthful offender claim, and I want to just sort of go back to where we start in this case, which is People versus Rudolph and People versus Middlebrooks, where the Court of Appeals recognized the importance of youthful offender status in our system. Young people like Mr. Hall, who was 17 years old at the time, they're much more likely to be rehabilitated and change their lives than an older offender. And one of the things that really strikes me about Rudolph is that it recognizes that youthful offender status is important to the community, not just the individual. And the community of Rochester is losing one of its young men to incarceration. And the community itself deserves a judicial
But the court did decide the YO issue. It made a decision on it and said no, correct?
It did briefly mention youthful offender status at sentencing. I don't dispute that, Justice
It did
Kern.
everything it was supposed to do. The court did.
I disagree. And the main reason I disagree is because the court has a mistake in front of it. It has a PSI that says this is an armed felony offense, therefore mitigating circumstances must be shown. And that's...
The mistake didn't matter. The court, is the court supposed to say, I've considered YO and I deny it, and by the way, the PSI was wrong, but it doesn't matter because I just denied it? That seems like a useless enterprise, don't you agree?
I disagree, Justice Kern, and the reason I disagree is that I don't think that a court can properly make a YO determination unless it has the correct information in front of it.
Well,
So
shouldn't the defense counsel then point out that mistake in the record of the PSI before sentencing?
I agree, and that's the ineffective assistance of counsel claim that we're raising in this brief, is that when the PSI makes this crucial mistake, essentially saying that Mr. Hall was presumptively ineligible for youthful offender treatment, it was incumbent upon counsel to correct that mistake so that the court, when it was making its youthful offender determination, at least knew that Mr. Hall was presumptively eligible, like any other 17-year-old.
Give some facts, but I think Justice Kern's point is this is not a Rudolph case, and you're not arguing as a Rudolph case.
No.
Your brief does not take issue with the judge denying the request. You're taking issue with the lawyer for not pointing out the error in the PSI and more vigorously arguing for YO.
That's correct, Your Honor.
And that error alone renders counsel ineffective at sentencing and should be sent back. But look, this guy, he knew he was getting 12 years. He was charged with murder. 25 to life is the max, 15 to life is the minimum. The lawyer negotiates a plea down to manslaughter first with 12 years determinate, which is impossible with YO. If you get YO, the maximum would be, I think, 1 1/3 to 4. So just by the nature of the plea, and he accepts, he knows he's getting 12, everybody knows YO's off the table. So you're saying the lawyer should have argued more for that? There's zero chance that Judge Argento is going to give him YO at that point on a homicide, pled down from a murder. So is that error, let's assume it's an error, did it have any effect? Doesn't seem likely that no matter what defense counsel said, this kid's getting YO when he kills somebody.
Well, 3 points, Justice Lindley. One, this is a manslaughter plea, but there are 2 co-defendants, and there's no indication in this record that Mr. Hall is more culpable than his co-defendants. It is never established on this record who pulled the trigger in this case. So
They took the plea earlier. I mean, counsel's there in December 9th, whatever it is, and the other 2 co-defendants have already taken a plea.
that's correct.
They're the first ones in the door. They might have gotten a better deal.
That's correct,
right,
Justice
as a
Kern.
result. So then, the best offer that defense counsel's got on December 9 is 12 to 16. That gets better for your client 2 weeks later when he gets 12 to terminal. So how is it that this is ineffective with not bringing up the mistake in the PSR?
With the plea, I think, again, I want to return to Rudolph, which says you cannot plea bargain youthful offender status away. They are purporting to have this plea bargain that's 12 years, but Rudolph says you must always consider youthful offender status at sentencing. You do not plea bargain it away. And again, that's because it's important to the community. You must have a record and build a record about whether youthful offender status is warranted so that the determination can be genuinely made. And returning to the ineffective assistance of counsel, this court has twice found that it's not ineffective assistance of counsel to fail to advocate for youthful offender status at sentencing, but what makes this case different is that you've got the mistake. The court not only does it have a lack of advocacy at sentencing for Mr. Hall to receive youthful offender status, but it is left thinking that Mr. Hall is presumptively ineligible for youthful offender status.
We understand the argument. Thank you.
Thank you, Your Honor.
Mr. McCarthy?
Thank you. Excuse me. Thank you, Your Honors. Marty McCarthy for the people. The first thing you have to presume is that the negotiations for this manslaughter in the first degree all occurred on the record in order to even consider defendant's argument. And that's probably not true. I mean, it's most likely not true. I imagine that there have been discussions in chambers on this. And I imagine in those discussions at chambers, counsel may have advocated for a youthful offender, and the judge said there's no way I would ever do that. So
defendant, if he wishes, could bring a 440 and say my lawyer is ineffective because he not once pushed for YO even during the plea. If he wanted to pursue that.
Theoretically, yes. And if he wanted to, in essence, vacate his plea with the determinate sentence of 12 years plus 5 years of post-release and face something with life on the back end, he's free to do that. But if absent that,
yeah, he wants to keep the plea, and he wants 1 1/3 to 4.
yeah, pretty much he wants to have his cake and eat it too. Nothing in this record indicates that the judge didn't correctly deny youthful offender, which the judge did deny on the record, and there is no way that a statement in the PSI, by the way, the statement in the PSI wasn't that he was not ineligible for youthful offender. That's not what the statement said.
Incarceration was mandatory or something like that, right?
Yeah, and
said it was an armed felony offense, so you got to go through some hurdles to get to work.
Correct. And at the end, in terms of the final, yes, it did say incarceration. That wasn't the incorrect statement that was focused on in the brief. It was the first one, which was the armed felony offense one. Whether that, it certainly was incorrect. That's clear. And if the court, if the defendant wants to go to Supreme Court for a order modifying the PSI for that purpose, he can do that as well. But there's no way the judge was somehow swayed by that statement. And it's like, oh, I guess what, I can't, there's no way I can give him a youthful offender. Because the other thing that didn't happen was the judge didn't put on the record, I find no mitigating circumstances. So there's no way the judge actually considered that incorrect.
The judge
statement.
actually reached the merits.
Yeah.
So this whole thing about armed felony
No,
was skipped over because the judge got to the merits.
because it was an incorrect statement
Right.
that the judge recognized.
thank you.
Because if the judge was swayed by it, the judge would have gone through that analysis.
Thank
There's
you.
no other questions?
Hearing none.
Thank you.
888, matter of 16 Main Street Property LLC versus Village of Geneseo.
Morning, Your Honors. May it please the Court. Charles Grieco, Bonchenick and King for Appellate 16 Main Street Properties, LLC. There's three issues on this appeal, Your Honor, related to a series of denials, the denial of three appeals of determinations or alleged determinations, purported determinations by the code enforcement officer denying the appellant the right to continue to use the property in a way that it had been historically used. And in the alternative, the appellant applied for two variances to allow the only economical use of this 3,500 square foot, 7-bedroom, 2-kitchen structure. And lastly, there's the issue of the plenary causes of action, which Supreme Court summarily dismissed, essentially converting a motion to dismiss under 3211 to a summary judgment motion without notice to the parties. I will address each of those as briefly as I can in order. With respect to the appeals, frankly, it's our position that this court's very recent holding in the Gutman case controls. There was absolutely no articulation of the bases for the denial of the the appeals here. There was no basis given by the code enforcement officer for why he determined this wasn't a legal non-conforming two-family dwelling. He simply said, I disagree, can't approve this. There was no articulation by the code enforcement officer why he denied the appeal that it qualified as a single-family dwelling with up to 8 occupants. And there was absolutely no articulation by the code enforcement officer as to why it could not qualify as a bed and breakfast with a property manager of the LLC standing in place of the owner of the bed and breakfast.
Did you submit it should be remitted for the ZBA to give some reasons on that?
So we think actually it should be remanded, or it should be annulled, and the appeals should have been ordered to be granted, given that not only are there no grounds were given, but actually the record shows that there were no grounds, and certainly the record we think establishes here, most importantly, that this is in fact qualifies as a legal non-conforming two-family property. How do we know that? Because they admitted it in their verified answer. They could not be more clear that they said that this property received a use variance in 1997 that had previously been used as a two-family, got a use variance in 1997 to operate as a bed and breakfast, but then that ceased, and it reverted to a two-family. This was a verified answer by the village, and now on appeal, they're trying to walk that back. They're trying to point you to various things in the record, which again, we don't think it's appropriate for the court it's not the duty of the court. It would be inappropriate for the court to search this record to try to find a rational basis that contradicts their own affirmative averment that this was in fact reverted to a two-family use prior to the appellant acquiring the property. So we think that is the appropriate remedy here, although, again, if the court deems it appropriate to remit, we can present that evidence again and deal with it. But we think under these facts, under this record, the appropriate remedy here is to order the granting of the appeal because, again, the respondents have essentially admitted it. With respect to the appeals, which were sought in the alternative, again, we think there the grounds, there were two variances here, both an area variance and a use variance, but essentially they were both aimed at the same thing, which was to continue to be able to use this property in a way that made sense. I mean, what the village here ended up doing was saying you can occupy that with 3 people. Again, this is a 7-bedroom, 2-unit building.
And they did grant a permit twice to allow 8 people in there.
They had.
Now, they say that was by mistake, but it had been, the prior owner, it sounds like your client wasn't going to buy it until the seller got a permit.
That's correct.
Seller gets a permit, your guy thinks, okay, I can have 8, then he gets a permit, and then all of a sudden the rug's pulled out.
And absolutely, they pulled the rug out from underneath him, absolutely. And it was all, and I think the record is perfectly clear here, is what precipitated that was a vocal minority of opposition. And this court, and the Court of Appeals, and your sister appellate divisions could not be more clear, and I don't think the record in this case could be more clear, that you cannot deny variances or make any other determinations based on these sort of generalized community opposition, which is all we have here. There's, I mean, you know, we cite the many instances in our brief where the ZBA was quite explicit as to how it was making its decision. Many neighbors have presented arguments against more than 3 tenants without owner present. The neighbors have voiced their concern. Neighbors have come out in large numbers to object. Neighbors are opposed. The neighbors have voiced their concerns multiple times. That's not even all of them, Your Honor. So we think the record here is crystal clear, and I think it's worth noting, as we point out in our reply papers, that subsequent to this, in a related litigation involving the same parties, for another area variance where my client was trying to seek an alternative way to use this property as a permitted use, which is an inn that required a minor area variance, the ZBA did exactly the same thing. If you look, and we pointed the court to the docket in that case, and if you look at what the ZBA did there and what the ZBA did here and their reliance, and just said, look, the neighbors don't want it, sorry, denied. This time, Judge Van Allen, I think, sensing, hey, you know what, there's a pattern here, because it was Judge Van Allen again. He not only, you know, he annulled it, and he ordered the granting of that variance. So we think the same remedy is appropriate here. We don't think the record, as I said, could be any more clear that that's what they were basing these decisions on. As we also pointed out with respect to the variances, we think there was a failure here to adhere to their own precedent. In response to that, the respondents argue, well, we're permitted to deviate from prior precedent. The problem here is, as the Court of Appeals made clear in Tall Trees, sure you can, but you got to give a reason. You have to explain it. The only evidence in this record is that the 4 instances that the appellant put before the ZBA of prior variances that were granted to allow increases in occupancy. And that wasn't discussed at all by the ZBA. It wasn't even acknowledged. So there cannot even be an argument that they gave a reason as to why they deviated from their administrative precedent. So that's another reason why that area variance should be annulled.
And just for my notes, real quick.
Sure.
As of right now, your client can use that property as a single-family residence or a boarding house with 3 occupants.
That's correct.
That's it.
That's correct. Okay. And with respect to the use variance, again, we also think the record shows in that case that, well, one more thing on the area variance I want to point out again. The other thing that's important to note, we obviously cite extensively in our brief to the Cassire case. I hope I'm pronouncing that correctly. The respondents seek to and spend some time to try to distinguish that case. We don't think they accurately describe what happened in that case or the facts of this case, but the important thing to note is I think the difficulty that the respondents have in making that argument is, again, in the related litigation, Judge Van Allen explicitly held that Cassire, hey, you're right, you know, this case is pretty much on all fours. I'm persuaded by Cassire. That's another reason he said, look, you guys you can't just without a rational basis deny these variants and allow somebody to continue to use the property in the same way it's been used for years, which is in both the facts of Cassire and the facts of here. So Judge Van Allen has already determined that case is essentially persuasive authority, so we don't think it really can be distinguished. With respect to the use variances, we point out we think that they dismissed the financial evidence without any contrary evidence in the record, and that was an arbitrary decision as well. And again, the use variance, just like the area variance, it's so plainly based on generalized community opposition. Lastly, with respect to the plenary causes of action, again, we think it's pretty clear here, and the respondents have essentially conceded, not essentially, they explicitly conceded that there was no notice. This was not, they didn't make a summary judgment motion. The court didn't say it was treating it like a summary judgment motion, didn't give anybody notice that it was treating it as a summary judgment motion, but simply granted, dismissed it as if it were a summary judgment on the grounds that the appellant failed to prove its case. That's not the standard that governs the 3211 motion.
Could we find that you nevertheless charted your own course in a summary judgment?
Well, that is an argument that the respondents made in their reply, in their opposition papers. However, they don't cite any authority, any analogous cases where that happened. They don't point to anything in this record to establish that that's what happened here. In fact,
certainly there's case law, sir, that says that when the parties chart their own course for a summary judgment path, we're going to honor their path. You basically stipulate it to the procedure.
I don't dispute that, Justice Curran, although they don't cite any of that case law, and we don't think the facts show that. In fact, in their briefs, they largely argued, look, these plenary causes of action aren't even really properly before this court. This is in Article 78. That's the way they treated this. Now, they did go on to address the merits, and we pointed out that these are meritorious claims, but then the judge treated that as a summary judgment motion. And I think it's important to recognize that the one case they do cite after they say that this was a charting a summary judgment course, the Sheave case, I'm not sure if I'm pronouncing that correctly, that case doesn't stand for that proposition. In fact, in that case, the court reversed the dismissal on the very grounds that we're arguing here, which is that this was a motion to dismiss, and you were treating this as a summary judgment motion.
Your time is up. Okay, thank you.
Thank you.
Your Honors, Matt Simmons, Underberg Kessler for the respondent.
Good morning, Mr. Simmons.
Morning. Your Honors, the issue here today is whether it was rational for the ZBT to forbid the petitioner from using the property in a manner which is specifically prohibited by code and which had never been used in the past, specifically a rental for up to 8 students. And here the record contains sufficient evidence to support the rationality of that decision, that first, this use isn't permitted, and second...
But he had a building permit that allowed him to do it, right?
Which was issued in error, yes. And
so it wasn't so unusual to allow this that the building inspector, the CEO said, oh, this is so unusual, I caught this mistake right away. They issued the permit.
Twice.
That's a pretty big mistake.
Yes, that is a mistake, and they did issue the permit. However, if you look at the history of the use of this property, as testified to by numerous citizens who have actual knowledge, personal knowledge, who live either next door to the property or have lived there their whole life, it has never been used for an 8-person rental. There's no evidence in the record that it's ever been used for an 8-person rental. There is one rental permit that allows for up to 8 for boarding house, but that's clearly erroneous because the code defines boarding house to limit it to 3. So, and as the court said in matter of Parkview, it's well settled that permits issued by mistake confer no rights. The petitioner can't claim some sort of estoppel because the CEO made a mistake and issued a permit that 3 months later he took back.
What do you make of the argument the council made that the ZBA needs to articulate reasons here and that we can't fill in the blanks, you're filling in the blanks?
My argument is they were clear as to the reasons. In both the August 5th minutes and the November 2nd minutes, as to the variances, the use and area variance, They go through each member present goes through each factor one by one and states on the record what their reasoning is. And I'd also point out that these decisions aren't made in a vacuum. It was clearly argued below. I mean, it was clear the issue was, as to the permit, for example, for a two-family dwelling. The issue was clearly whether it was a prior lawful non-conforming use, and even the petitioner's attorney below admitted that that is why the ZBA denied it, because they determined it was not a prior lawful non-conforming use. So everyone, it's clear what the basis of the ZBA's determinations were. It's very clear from the record. The fact that they don't have a written piece of paper, spelling it out, I think, shouldn't matter in this instance. Also, just to address petitioner's use of the case of Kaxmeyer, I would suggest that that case is completely different than what we have here. There are many similar facts in that case. However, in that case, the person that bought the property bought it and used it for 9 years as a two-family dwelling before that use was basically taken away. Not only that, when they bought it, and at the time the use was the variance was denied, two-family dwellings were permitted in that zoning area. So that's completely different than what we have here. We don't have here the petitioner bought the property knowing that two-family dwellings, or he should have known that two-family dwellings are not permitted. And in that, also in Kaxmeyer, the property had been used for 50 years prior to that as a two-family, the 9 years as a two-family. So we feel that case is extremely distinguishable. And let's see.
Just to be heard on the last point about the conversion of the motion to dismiss and that cause of action, that plenary action.
I'm sorry.
His last point.
Yes.
On the plenary causes of action for negligence, constitutional violation, there's a third one that's I've lost.
I mean, we concede that below we did not move for summary judgment or argue for summary judgment.
It's tough for the movement to say, hey, I moved for it to dismiss, but I really charted a summary judgment motion.
Yeah, and our argument is that all the arguments are there. The court, we did argue the merits of the motion, first of all, and petitioner did respond to the merits argument. And also we know, just we would argue out of sort of a, judicial convenience or what have you. It's very clear from the record on this case that none of the three causes of action have merit. I mean, it's very clear from the record.
We have some case law on one of them as well.
Yes, for example.
Family issue.
Yes, Your Honor. This court, as to the definition of family, this court in 2001 found it was fine. It's not illegal to discriminate against, Brockport v. Webster is basically a case involving an identical definition of family. And we said it was fine. There was the Atlas Henrietta case, which was a lower court case, which said the same thing.
Mr. Simmons, what about the boarding house issue? They argue that there's an inconsistent application, an unconstitutionally so inconsistent application with respect to boarding houses and the numbers permitted therein. Doesn't that survive here? I mean, when you think about it, that could only be dismissed by summary judgment, and all you have is a motion to dismiss. So if we don't find that you charted it, doesn't the boarding house allegation survive?
I wouldn't think so, Your Honor, just because the code is very clear that a boarding house is just 2 or 3 non-related individuals. It's basically a definition.
But given the fact that one permit at least was issued for a boarding house for 8 people at least one time in the history of the village,
yes,
shouldn't they be given an opportunity to show there was an unconstitutional selective enforcement argument, which might not be the greatest, but still it's there, that if you've been doing this all the time before, and now all of a sudden, oh yeah, now we're going to force the code as to this particular person, shouldn't that survive?
Your Honor, I don't think there's any evidence of the village doing that before, other than the
And if
mistaken.
this was summary judgment and you had carried your burden, you might be in the game.
Yes, Your Honor.
Anything further, Mr. Simmons?
No, that's it.
All right, thank you. Case 889, Morrison versus South Union.
Good morning, Your Honors.
Good morning.
May it please the Court. Peter Kushoyan on behalf of Jasmine Morrison. I'm the respondent.
Okay, I'm sorry. Yeah, so we have, the defendants are submitted,
That's correct, Your Honor.
and you wish for us to affirm.
That's correct, Your Honor.
Does the panel have any questions on some of these issues?
I have a question with respect to the argument that was made concerning the lost wage claim, that's something that wasn't sufficiently proven at trial. Explain why the proof was sufficient at trial.
Yes, Your Honor. First of all, her treating neurologist said she could no longer work as a hospice nurse anymore. That was her entire work experience, was as a hospice nurse, and she's going to need a lifetime treatment over the next 30 years because she's got a permanent brain injury, permanent back injury, permanent neck injury. So I think the jury certainly had enough to make a reasonable inference that she was disabled for the remainder of her life.
And Mr. Kushoyan, to follow up on that, and Justice Nowak, I didn't mean to interrupt your follow-up question. Go ahead, sir.
No, that's all right.
But it's a weight argument the defendant's making on the future wages, right? It's a weight, not sufficiency.
That's correct.
So there'd have to be nothing to support the future wage award in order for us to find, not nothing, but no reasonable view of the evidence, well, whatever the usual standard is. So we'd have to look at the record. Can you point to us, if there is any, record evidence to support the weight for an award of future wages? I'm not sure we have any medical testimony to support it, but give me your argument on that with respect to what evidence there is in the record that I should look for to find that you carried the weight.
Yes, Your Honor. With respect, well, the treating neurologist did testify she was completely disabled from her job as a hospice nurse. That was Dr. Giglio.
And that's not the same as saying she can never work.
In that field. But the remainder of the evidence, he also testified that she had a permanent injury to her brain, her back and her neck. She had cognitive disability, memory issues, and that was also supported by the lay witness testimony. And that she's going to need, and the jury also found she's going to need continued medical treatment for the next 30 years.
And your client, didn't she testify, and perhaps it was on cross, that she doesn't think she could ever work again?
That's correct. And she's still physically and mentally disabled to this day.
Even though I was going to pass on a question, I want to ask you, do you agree that the law is as follows? And it might be different than what Supreme Court said with respect to the workers' comp defense vis-a-vis suburban only. So the Supreme Court cited a case that had just one line saying that it was waived. But in this situation, if we're just looking at whether or not you carried your burden and whether or not there's a triable question of fact raised by defense on the workers' comp defense, can't they raise that basically at any time? There's the Murray case from the Court of Appeals, where it was raised after the plaintiff rested at trial. There's one where the default judgment was entered, and they were able to still raise it later. I mean, when you use it in a defensive posture as a defendant, as opposed to offensively moving for summary judgment, can't you essentially raise it at any time and ask the court to conform the pleadings to the evidence?
It can be raised. However, there has to be evidence, prima facie evidence to support it. And there was no prima facie evidence to support it.
So you would say, even if we decided that the Supreme Court made the mistake on that it's waived at the summary judgment stage, you're saying that there's still not a question of fact on that issue?
That's correct.
Was my understanding of the facts, and you can correct me if I'm wrong, is the special employee, this workers' compensation affirmative defense was not pled in the answer.
That's correct.
We have 5.5 years of litigation discovery, and then we have summary judgment motions. And for the first time after 5.5 years, the defendants raised this issue, did not move to amend their answer.
Correct.
Do we have all those facts right? So were you, your position, is it not that this was prejudice, this comes out of the blue. If I had known you were raising this defense, I would have asked some questions in discovery. We could have developed this. So even if you raise an issue of fact and meet your initial burden, what have you, it's not waived, as Justice Curran said, but you can't spring this without moving to amend your answer. Is that your position?
Yes, it is, Judge.
But the question really distills then to is, can you do this in an offensive or defensive posture? They clearly couldn't get summary judgment dismissing it on that basis, but the suggestion is being made, and it's a legitimate one, that maybe they can defend your motion on that ground. And that's something we have to look into. Do you have any closing thoughts on that issue?
I think when they raised that issue, they cross-moved to dismiss my claim based on that defense, and the court rightly found that the affidavit they submitted was not somebody with any personal knowledge.
Right, so you're just getting right to the merits.
Yes.
Yeah, they lose regardless of whether it's waived or not. They just didn't.
Right, they
establish it.
didn't establish someone with personal knowledge.
Gotcha. All right, anything further? Thank you, counsel.
Thank you, Your Honor.
Case 890, Robert Drum versus the Village Mobile Home Park, PLLC. Mr. Collins, you're alone today, and your brief is very thorough. Do you wish to expand on anything there for our edification?
I have nothing to expand upon, just to state that, I think the court, for multiple reasons, erred in granting summary judgment in the defendant's favor. The affidavit submitted by Lori Englert, the property manager, was not stated to be based on personal knowledge, and there's no reason to indicate that she had any personal knowledge. There were two agents apparently who run the park on a day-to-day basis on behalf of the owner. They did not submit affidavits. There's, simply a failure to establish a prima facie case of lack of notice.
You rely on this doctrine that we invoked recently, that if the matters are exclusively in the knowledge of the one party, then we just can't take their word for it, and that's necessarily an issue of fact.
That's right. That was most recently iterated in the case of Michael P. versus Dombrowski, on which Justice Curran sat. It involved very similar case, dog bite, motion to dismiss, converted to one for summary judgment.
We did see that. Anything further?
That's it, Your Honor.
I'm sorry, one real quick question. Where in the record do we find the evidence about there being two agents that knew what was going on at the property? Because I saw that the plaintiff didn't submit his own affidavit in opposition to the motion.
The lease agreement, Your Honor, which is at page 43 through 45 of the record, it's signed on behalf of the park by Russell and Jeannie Swatsworth, who are identified in paragraph 12 at page 45 of the record as the agents for the park, and obviously as signatories to the lease. I think it's fair to infer, or at least raise a question of fact, as to whether they were there, as the park's agents on a day-to-day basis, because they are the persons who are designated, as agents in paragraph 12. And there's a reference in one of the police, or rather the county's dog bite investigation reports that says spoke to Jeannie in the office. I think it's again fair to infer that that's a reference to Jeannie Swatsworth. And we just don't have any proof from them as to what they ostensibly didn't know.
Your argument is that the property manager's affidavit doesn't establishes she didn't know the dogs were there, but it doesn't establish that these other two principals who were involved didn't know, and to meet their burden, they needed affidavits from all three.
That's right. And the property manager doesn't even say that what she states is stated on personal knowledge. It's unknown whether she was ever, at the premises during relevant times. Thank you.
Thank you. 891, State of New York versus Nathan E.
Good morning, Your Honors. Maurice Ferrillo appearing for Nathan E. This is a mental abnormality.
Just make sure we have Mr. Brady is going to be joining us virtually, so let me make sure that he is with us. I don't see him yet. And there he is. You may proceed, thank you.
This is an appeal related to a mental abnormality determination, and we have the following issues, Your Honors. First, legal insufficiency. It's our position that the state failed to establish a mental disorder, that it predisposed the appellant to sex offenses and resulted in serious difficulty controlling urges or behavior. The state did not establish those elements. The first point I'd make is that the state did not establish the conduct constituted recurrent activities, fantasies, or urges for at least 6 months as required for a pedophilic disorder, which is what the state claimed. I point out the following. With respect to the underlying cases, there was one case in Livingston County was for a few months where the allegations were made, and then there's a second case in Monroe County.
It's the one he pleaded guilty to.
Yes, and where there was a period of 2 months.
Attempting to anally rape a young child.
Attempted Criminal Sex Act. And my issue with that, as I indicated in the motions, was that the state relied on some police reports. They didn't have any grand jury testimony or affidavits from the individuals. I had raised a Floyd Y issue as to that. The other issue that I want to point out is that this particular case involves a situation where the appellant was done with probation in 2015. In October of 2015, he went to Virginia with his girlfriend. They eventually married. And for a period of 18 months, he had no issues. There was no problem with urges. There was no problem with instances. He was working. He was in therapy. So that evidence is inconsistent with the theory that the state alleges is that he's got basically an uncontrollable obsession with children. They didn't establish that he was preoccupied with children. He had got involved with these two women. They may not have been the best women to get involved with, but he got involved with them.
On the other hand, he got involved when they had small children, and he would masturbate compulsively in front of the children and the grandmother many times a day out in the open. Was asked to stop and did not. That seemed to happen in both residences.
Well, in the first case, he had issues with alcohol. He had PTSD issues. I don't think it's disputed. He served a number of tours in Iraq and Afghanistan, and he was dealing with a lot of issues. But the 2015 on period, he did very well. So I think that's inconsistent with, again, we're not talking about, the underlying acts, but we're talking about these elements under mental abnormality that they have to show, which I think they haven't shown. And I also would point out that with respect to the assessments, they did not show any current or recurrent thoughts or obsessions. I did cite the Kenneth Groves case, et cetera. Dr. Lord's claim of hypersexuality is insufficient under Gen C. Dr. Jensen, who did the forensic evaluation, talked to the appellant and did not have any current fantasies, and he did well in his program through the extensive sessions in state prison. So on the sufficiency issue, we have an issue with the sufficiency of the first prong, the sufficiency of the evidence. There's also an issue with the decision of the court as to it being contrary to the weight of the credible evidence. The lower court rendered its decision without any findings, and then the state submitted a set of findings that they asked the court to assume. I point out again, we have an 18-month period of no offending. I would submit they did not properly weigh the successful treatment of the SOTP program. He had no tickets, no problems. He was a model prisoner. Again, I would submit they did not establish the pedophilic disorder. The state's experts essentially relied on the underlying criminal activity, which is an improper basis for determination. I did cite the Donald D.D. case. Mere fact of prior criminal sexual conviction standing alone is not sufficient. And again, I think the subsequent conduct that occurred here, we have evidence of that 18-month period, absence of offenses, absence of tickets, et cetera. I think that's very, very material stuff that was not properly weighed, and I did cite the Frank P. case. Now let's talk a little bit about the experts. Dr. Bard testified. He handled many cases, and this case did not meet the criteria of pedophilic disorder. This individual, the appellant, first incident of sex offense was in his 30s, which was not typical in his opinion. Dr. Bard also found it was not common to find a mental abnormality outside of the DSM-5. And as he said in his testimony, pedophiles seek out children for sexual gratification. The history was a long history of contact with adult females, not children. The PTSD issue and the alcohol abuse, which was occurring, especially during the first incident, Dr. Bard found contributed to the events for which he was convicted. I would also submit the distinction that when you go from 2015 on, he got involved with Kimberly, his now wife. He's had her support. She's been involved throughout his state prison time and so forth. And those facts are different than what he went through when he came back from, whether it was Iraq or Afghanistan, and all of the trauma
like
that he went through.
What the theory was is when he's not drinking or if he's not affected by PSD, he's fine. Once he starts drinking, then he starts masturbating in front of children and anally raping them and doing all sorts of sexual acts. And therefore, as long as he's not drinking and he's getting treatment, he's good. I mean, this guy got cyst. Like, when I was reading the facts, usually under these facts, we see people who are confined. So he's doing well, and I understand you make a lot of legal arguments. He shouldn't even be under cyst at all.
Right.
But the result here was better than it could have been.
Well, and it's in the record, so I'm not saying anything that's not known. He had a terms of release. He was getting ready to be released to Virginia.
Right.
They had all the terms down. He had restrictions. He wasn't, he was going to have things to do, and very motivated. And then a few days before that, he got hit with this petition. So, and we're not suggesting that he shouldn't have treatment, and he's following through with everything. He's been a model prisoner and so forth. But there are obviously restrictions that are added, whether it's cyst or whatever, and that's why we have these requirements in the mental abnormality requirements as to clear and convincing evidence. So it's our position that that is a distinction. I'd also point out, even from the government's own evidence, they said Dr. Jensen, who was the forensic examiner, said that he had successfully completed SOTP that reduced his risk. He had no fantasies or urges when she interviewed him. She testified that children are not his preferences. That's what she said. Also, that he's able to control his behavior when he chooses to. So again, the statute talks about, in essence, uncontrollable urges. He's able to control himself. He was able to do that, obviously, for the 18 months. She said he did well when he was with his spouse in Virginia. And Dr. Lord said that he was able to be treated. So I'm not minimizing what he was convicted of, but in terms of the statute, it has special requirements. And I would submit in this case that under the mental hygiene law 1003I, that the state did not meet the requirements of the mental abnormality, and that the lower court's determination should be reversed and the petition dismissed against him.
Thank you, Mr. Brady.
Thank you. Thank you, Your Honors.
Mr. Brady, you need to unmute. You may proceed.
Thank you, Your Honor. Obviously, the two states' experts found that the respondent suffers from pedophilic disorder and also has other conditions, post-traumatic stress syndrome, which is in remission. Dr. Lord found that he has several antisocial traits, and that the pedophilic disorder in combination with the PTSD and the antisocial traits caused him serious difficulty in controlling his sex offending conduct. As far as the legal insufficiency argument with respect to whether or not he has recurrent fantasies for at least 6 months, the definition says that what is the 6 months duration is for fantasies or behaviors. In his case, the doctors relied on the fact that he had a recurrent pedophilic behaviors and that was over a period of 14 months. The purpose of the 6 months, as the doctors testified, that the purpose of the 6 month period is to make sure that the pedophilic urges are not transient when you're giving this diagnosis. Here, they were not transient. It was over a 14-month period. The fact that he was in the community for a period of roughly 18 months and didn't commit a sex offense is laudable, but it doesn't vitiate the finding of mental abnormality. The fact is that people who have suffered from pedophilic disorder often go periods of time without committing a new offense. The manual, the DSM, actually says that, these symptoms will wax and wane over time. And in this case, Dr. Lord also testified that part of that period that he was in Virginia living with his now wife, that was after he began to do that after he committed the second set of offenses. And he kind of speculated that that the respondent knew like a storm was coming. He was on good behavior because he knew that he was going to be called to account for the second set of sex offending behaviors against the young children. He also obviously has serious difficulty controlling these pedophilic urges. As we can see, he began courting the woman and her children in the second set of offenses at the exact same time that he was facing charges on the first set of offenses, and at the exact same time that he was speaking to North Coast Counseling about what his sex offender treatment needs might be. Of course, he did not divulge the fact that he was at that time involved with another woman and her young children. The other thing I just wanted to mention is that the respondent raised an issue about hearsay, that the experts couldn't rely on the statements, the verified statements of the victims. I think that's clearly, that reliance was clearly authorized by Floyd Y. Floyd Y says that statements are reliable if they're connected to criminal convictions. These statements, the statements here were both connected to criminal convictions regarding both sets of offenses. Unless the court has any particular questions, I'm prepared to rest on my brief.
Hearing none, thank you. 892 is Jefferson County Director versus Tad M.
Good morning, Justices.
Good morning.
May it please the Court. I'm Terrence Brennan from the Jefferson County Attorney's Office, representing the Director of Community Services for that county. We're asking the Court to reverse and remand the Supreme Court's memorandum decision and order that granted a motion for anonymity in the caption of a mental hygiene law, Kendra's Law case. The basis of that is that based on this court's precedent, which is, I believe the case is PB7 Doe versus Amherst Central School, 2021, the court should exercise its discretion to limit the public nature of judicial proceedings sparingly and then only when circumstances necessitate it. So the first argument I had was that there was insufficient finding of fact of any unusual circumstances before granting this motion. It was based on whether the respondent may experience severe stigma.
What's the benefit? I don't, it sounds like this is being done confidentiality all over the 5th Judicial District, and why does your client, what's the benefit here of having this individual's name disclosed publicly like this? What benefit does it give to anybody?
Well, this, the nature of the exposure, if you will, is the ability for the public to, for example, search the person's name. When that's done, it does not disclose any information about the case. That's the status quo that I believe the judge also made a clear error factually in making the decision. When you look up somebody's name and it's a mental hygiene law case for Kendra's Law, it states clearly, this case is not available to the public online. Contact the court for access. It doesn't mention the person's name, but it does give you a result and directions on how to access the case.
Mr. Brennan, you know that we use initials for people that you just heard about in the last appeal.
Yes.
In Article 10. And this is somebody with mental health issues, right?
Correct.
And now, you know that we have very few cases on this particular statute. The only one I can find is the one that I was on, along, I think, with Justice Lindley as well, back in June of this year. And there we used initials.
Yes, I believe the court system does have provisions for maintaining privacy for cases that are published. And I think at this stage, these cases are published online in the court calendar.
So you would acknowledge that on appeal, we're going to use an initial?
Absolutely. That's what the rules already provide for.
So if we use an initial, why should the Supreme Court of the trial court?
Well, if you take away the...
We're the one with more published decisions.
Right.
Typically.
But the court calendars and the court records that the public has access to, when they search up a litigant's name who's part of a Kendra's Law case, they may have the right to access that case, but they need to ask the judge first. So the status quo now is that blanket statement that I stated to you, that you don't have access to this case, contact the court for more access.
Give me an example where you think this would matter.
It may matter, depends on who is properly interested, and that goes to Mental Hygiene Law 9.31F, which seals these records. So there is some protection already. That states
protection, but why would it matter? Give me an example of to whom and why it would matter to anyone to look this up and find the name that you're so concerned about.
I would say any member of the community or a neighbor. If you know the person's name and you may be concerned about their behavior. So you look that up in the court records and it says you don't have access to this case.
All right, so there may be concern, somebody moves in next to somebody who has mental illness, the neighbor should know, hey, there's a guy with mental illness next door, maybe we should watch out for him?
Well, the nature of Kendra's Law...
Lock the kids up?
No, I'm saying the nature of Kendra's Law is the person is attempting to be maintained in the community, and that's part of my client's efforts, is to maintain them there. So I don't think it helps lessen stigma by trying to cover things up and make the case secret, so to speak.
All right. Anything further?
The judge found that there was that the records of the Mr. Tad M were open for the public to peruse, and that was clear error. That was not the case, and we explained that in my brief, that it was a court's software error that allowed some other case to be exposed.
The basis, just, you mentioned how it's important now for the neighbors to know, and we can discuss that, but in the petition, it was Ms. Rupert, the coordinator of mental health services, said it would be extremely difficult to have coordination and collaboration for services without having the full name as opposed to the abbreviated name. And that I don't understand why it would matter at all.
Within the county, most of the service agencies would know the name of the person.
Right.
But in other counties, for example, I think that's what she was concerned about. If somebody leaves our county that's under a Kendra's Law order, she has the obligation to go find the person. She has to check police agencies, morgues, all the hospitals that they may have gone to. So she does use the order for that purpose, to link that person that she's looking for to the treatment.
She wouldn't have any access to any records that have the full name? And in fact, a lot of other identifying information of the individual?
She meaning?
Ms. Rupert.
Ms. Rupert knows all the information about the person. Point. But the other counties do not, and she's trying to connect herself to that person, saying this person is ordered to receive mental health treatment.
So by using the pronoun she, you're referring to a person like Ms. Rupert in a different county that's trying to do something as opposed to Ms. Rupert herself, because Ms. Rupert has all the information.
Right, but her job is to coordinate with all the services that this person needs. And that may be in another county, and she may need to contact other agencies and explain who the person is and send them a copy of the order.
But the abbreviated name doesn't prohibit her from using the full name when she has those communications?
No, it does not.
Fair enough.
Is there any public safety, is this motivated by public safety concerns? Have there been patients under Kendra order who have caused harm to people that if the name had been disclosed, the people might not have been harmed?
Not that I'm aware of, but I was bringing up the concern for potential confusion or just people saying, I can't share information with you to Ms. Rupert.
Right, no, I'm just talking about, you were talking about neighbors and so forth, people in the community need to know, like Scarlett, you got to brand this guy, look, here's somebody who's mentally ill, everyone keep your distance type feeling, doesn't seem to have any public safety rationale to it.
No, but the person's name, if I can analogize, everybody under the status quo, if you look them up online for the court records, you get kind of a door that's locked. Taking their name out of the caption takes them out of the index, so the door is gone. You would have no way of knowing whether they have any court involvement at all. And not just neighbors, but any member of the public, they have a right to know what's going on in court.
Gotcha. All right, thank you.
Good morning, Your Honor. David Agigian, Mental Hygiene Legal Service for the respondent. And the court's questions are certainly valid. And it is significant that the use of anonymous captions are so pervasive, not only through the 5th Judicial District, but in speaking with the 7th and 8th Judicial District Mental Hygiene Legal Service, they're not aware of any other director of community services or hospital or prison that has disputed that anonymity is that patients are entitled to anonymity under mental hygiene law and under specifically Article 9. And even within Jefferson County, Samaritan Medical Center Inpatient Mental Health Unit, when they commence an Article 9 proceeding, they do so with just the patient's initials. And why that's significant is that I think it's proof that the mental hygiene law is unambiguous with respect to the patient's records, information, and even identity are not for public consumption. 3313C is pretty explicit about that it is not for public consumption, and it goes on to even articulate and clarify that includes, quote, the identification of patients or clients and clinical records or clinical information tending to identify patients or clients, unquote. So it's clear that the mental hygiene law is there to protect the anonymity of these patients because there is a stigma out there. And I would also note, it's clear that this Section 9.60, which covers these proceedings for assisted outpatient treatment, is in the mental hygiene law. I think that proves that the legislature was not thinking of making a de facto registry in somewhat like the sex offender registry. This was not the intention. If it did, it could have put it in the correction law or the penal law or somewhere else. This is under the mental hygiene law, and it's understood that the mental hygiene law is there to benefit patients, to benefit their anonymity.
If we were to grant the petition here and identify this individual, in this and other cases, could there be adverse effects on people's employment, relationships, friendships, so forth? If somebody's applying for a job, somebody does a run and check, this guy's under Kendra's law, might not get the job.
No, that's absolutely true, Your Honor. That's the stigma we're talking about, is that there's no evidence within this. And by the way, I also want to mention, there's a list of 18 exceptions to this requirement that a patient's information is protected and not to be disclosed publicly. 18 different separate ways that it can be disclosed to interested parties. And Appellate has not shown how that list is somehow inadequate or somehow not sufficient for the Director of Community Services to share that information. There's no evidence that that's the case. And so the public policy arguments here just don't fly as well because of that. So I think under the situation, Appellate just has not only shown, well, let me start this way, or let me end by just saying, I take issue with the appellant's statement that there's a public interest and a public right to know, because the mental hygiene law clearly states that that is not the case, and it's unambiguous, and I think courts throughout the state understand that as well as the litigants.
Thank you.
Thank you, Your Honor.
Case 893 is Albert J. versus State of New York. 893, we have the respondent by video. Counsel, good morning.
Good morning, Your Honors.
The appellant has submitted. Do you wish to be heard further beyond your compelling Written brief?
Your Honor, just 2 points I wanted to highlight from the brief relating to the basis for this finding of dangerousness. The first is that Albert J. continues to minimize the qualifying offenses and lacks insight into his sex offense cycle, which prevents him from forming meaningful plans to avoid future relapses. And the second is that he lacks any realistic plan to avoid relapsing on alcohol if released persists. And both experts opined that a relapse would greatly increase his risk of reoffending. With that, Your Honors, unless you have other questions, we'll rest on our brief.
Hearing none, thank you, counsel.
Thank you, Your Honors.
894 is Ogeen versus Macusland. $894. Mr. Wright, good morning. We have the appellant is here virtually. Counsel, you may proceed once you unmute yourself.
May it please the court. Good morning, Your Honors. My name is Nicholas Herzler, and I represent the defendant appellant in this case. Your Honors, we submit that the plaintiff in this case made a very perfunctory motion for summary judgment. The motion was not supported by evidence or any detail as to how VTL 1141 was violated under the circumstances of this case. We understand that, yes, the Subaru turned in front of the motorcycle, but it's not that simple. There are a lot more factors in play here, which we laid out in our brief. For example, there are so many unknowns. How much time did Mr. Ogeen have to react to the presence of the Subaru in front of him? We just have no idea on this record. What was the speed of the motorcycle? Consistently, we have, as the briefs show and as plaintiff admits in their brief, we have no idea how fast that motorcycle was going.
Well, don't we have some testimony from your client that 300 feet away and that 3 to 4 seconds elapsed after they waited for the vehicle? And then don't we have the expert testimony about 9.1 seconds equating to 600 feet, twice that distance? So can't we just do a little simple math to figure it out?
Your Honor, first of all, it wasn't 300 feet. My client testified in a very unscientific way. He said a football field, and his testimony was inconsistent. It was internally inconsistent, and he testified differently at the criminal proceeding before Judge Jones. And
I'm sorry, tell me why it was internally inconsistent.
well, because when you look at his testimony, he doesn't specifically, the questioning is very disjointed as far as he doesn't answer the questions. When you look at pages, excuse me, just one moment, he was not asked in a sequence of events. If you look at 135 through 9 of the record and 147 and 160, his testimony is unclear. He says, I observed the motorcycle 1 football field away, and then I waited 3 to 4 seconds, and then I turned left. What is a football field? Is that 300 feet? Is that 360 feet if it includes the end zones of the football field? He wasn't at 135 to 6 of the record. He was not asked the precise timing of when it was a football field away. He says he slowed down, he turned on his signal, he saw 2 oncoming vehicles, and then he was not directly asked how far away the motorcycle was when he turned left. At 137 of the record, he was asked if he saw it about a football field away. He said, quote, no, I saw the car and then I saw the motorcycle together. So he didn't directly answer that question that was asked. And when you compare that testimony, which is we submit is unclear, and the plaintiff's expert did not put together any math or any time, speed, and distance equation with that vague testimony. What is a football field? He didn't put that together and say this is the speed of the motorcycle. At no point in the expert's testimony or in the plaintiff's brief or anywhere in the record did they say this was the speed of the motorcycle based on that testimony, doing an equation and coming up with a specific number of how fast that motorcycle was. So it's
often, I would agree with you, it's often difficult in cases like this to come up with a specific number, and that you have to rely on recollections of the witnesses. Here, the decedent can't testify as to how fast he was going. Your client did not testify that the motorcycle was speeding, nor did Mr. Gulick, who was, I think, right behind your client, kind of with a perfect view of the entire situation. Mr. Gulick, in fact, testified he didn't think the motorcycle was going fast. So why isn't that enough? Why do we need to come up with a number? Why isn't testimony sufficient?
Judge Jones pointed out, Gulick did not have a good vantage point because he had the Subaru in front of him.
The
All
Subaru
right?
that was turning left.
Yeah, in front of the motorcycle, and he can't. I mean, he's got at least one vehicle in front of Gulick, and that's a very vague, statement to say it wasn't going fast. I mean, what does that mean? He's not asked a specific. He never says, a specific number of miles per hour, and. I mean,
So in the future, what you're saying is that a plaintiff was going to need to establish the miles per hour. Whether it's 33 or 47 or 68, like that's got to be established to get summary judgment going forward.
Among other things, yes. I mean, the fact that, and by the way, as we see in the record at 243, my client testified that that the motorcycle was about a football field distance when he began the turn, not that there was 3 to 4 seconds in between those two events.
Right, that was at his criminal trial, I believe he testified that. But it seems to be your primary point, excuse me, in the brief, is that there's burden shifting going on by the plaintiff. The plaintiff's briefs keep saying, you failed to prove this, the speed and so forth, and you point out that it was the plaintiff's motion for summary judgment, and even though you would have they have the burden of proof here, plaintiff's motion, as the movement has to establish as a matter of law these things, and he failed to meet that burden.
Absolutely. I mean, that encapsulates the point of our brief is that it was the plaintiff's motion. The plaintiff had to prove their case. They had to eliminate all these issues of fact. They had to talk about, resolve the testimony and submit a detailed expert affidavit that actually had a time, distance, and speed, analysis, and also accounted for, the additional evidence. I mean, I understand that Mr. Ogeen, obviously, unfortunately, it's a tragic situation. He cannot testify. However, there are other ways to establish things like how fast the motorcycle was going, and how much time he had to react, because we have the skid marks, the yaw marks, the physical evidence at the scene. And as Judge Jones pointed out, I think very cogently, the point of impact at the rear corner of that Subaru and the lack of very much damage at all. And we have a photograph of that in the record. If you look at that, it really shows that this was a glancing blow to the rear of the Subaru, where he almost was able to complete this turn without an impact whatsoever. So that really shows that this was, and my client consistently testified, he and his wife Gwendolyn testified, it appeared that he had plenty of room to make this turn. So those are the issues that the plaintiff had to rule out, and they just don't.
Counsel, let me just interrupt. I'm stuck on the conceptual point. The way I read the court's decision, it found that your client was negligent as a matter of law, and that as a matter of law, that negligence was the sole proximate cause of the accident. That's what the decision says. And in order for me to sort this out in my brain, what I typically do is I go through a verdict sheet that's pretty standard. So the first question on the verdict sheet would be, was your client negligent? The court answered that yes, as a matter of law. The court answered question 2, was that negligence a proximate cause of the accident? Obviously, the court answered that yes in both instances. The next question would be whether the decedent was negligent. The court skipped that question and went to question 4, assuming that there was negligence, and found that the decedent was not a proximate cause of the accident. So isn't your point that first the plaintiff needed to meet the burden as a matter of law to answer what I would call question 3, that the decedent was not as a matter of law negligent? You don't get to 4 unless you assume arguendo that the decedent may have been negligent. So once you get there, I mean, so that there's a conceptual problem here. The burden shifting was not met. Do I have that close?
Absolutely. I can't say it any better than that. And also, just to add to that point, it's just that, the plaintiff, just did not even acknowledge that it was their burden of proof to even meet, to show that there was no comparative fault here. And also that in a case like this, when you're talking about time, speed, and distance is the name of the game when you're talking about a VTL 1141. And so because of that, when we have an issue of fact as to comparative negligence, that's really intertwined with the question of negligence as well, because we need to resolve that. It's whether both parties and how much time they had to react and how much time and distance there was affects the negligence and the comparative negligence analysis.
The way I read your brief, your reply brief, is that we can't split the baby, so to speak. If we can't say the plaintiff established the defendant was negligent as a matter of law, but failed to establish that there was no comparative negligence. It's all or nothing in your view.
In my view, it is. I understand we're in a post-Rodriguez world, and so the Court of Appeals has said you can have partial negligence, but our point is that this is a unique case where, unlike in a case like Rodriguez, this is a case where comparative and negligence are intertwined. And so, to your point, Justice Lindley, that's correct. And so you can't split the baby that way under a case like this.
Anything further?
No, thank you for listening, and I'll rest on my brief.
All right. Mr. Wright, good morning to you.
Good afternoon, Your Honors.
Counsel suggests that you're stating forth the burdens of proof at trial in your brief, and he says that the burden is opposite on a motion for summary judgment, is what he says about your brief.
Absolutely not, Your Honor. This is the problem. There is no evidence of excessive speed. If you look at...
Time out. Just focus on what you said right there, Counselor. There's no evidence, okay? In other words, you're shifting the burden for them to put up their evidence. You have to prove as a matter of law, question 3, as I call it. Right. That is, as a matter of law, the decedent was not negligent. And one of the problems is, how is it that he just seems to glance off the back passenger at the last second? How is it that he, the decedent, didn't see the car turning in front of him? Why wasn't he, the decedent, able to avoid the accident? Aren't those all questions of fact that you needed to resolve through expert proof or witness testimony, one way or the other, as a matter of law in your favor?
Absolutely not.
Well, you do have to.
Well, think about it, Judge. Think about it. Look at every single case that the defendant or the appellant cited. Every single decision says that the plaintiff does not have to eliminate all comparative fault. Every single decision, every single one of them. And then it says, well, let's see what the defense says. In every single one of those cases, the defense had an affidavit or some evidence of excessive speed in the same fact pattern.
We're, as counsel said, I understand, we're post-Rodriguez.
Right.
You've got liability. You've got serious injury, right. You've got negligence, and you've got proximate cause. The clock, as they say, is running, right. Totally. But that's still, Rodriguez carved off the plaintiff's or here the decedent's comparative fault as a separate issue. And what my point is, to get to the fourth question on the verdict sheet, proximate cause of the decedent, you have to assume that the decedent was negligent. But you must first establish that the decedent was not negligent as a matter of law. I'm not so sure you did that.
Well, the case law is clear. The plaintiff in this case had the right to assume that they were going to obey this vehicle and traffic law. So he's going straight.
Not blindly so. The case law is pretty clear. But you can't just go through an intersection blindly.
He's not going through. He's not going through an intersection.
I know he's not in an intersection, but the same concept is true.
But if you look at the time, Judge, there's no way he had more than 4.5 seconds to react.
Let's look at the time then, because really what it comes down to is speeding. I think everyone would agree. Well, your client's got a really good argument on summary judgment on negligence. We're just talking about comparative fault here. Sounds like the only negligence, the primary piece of negligence here alleged against your client on the motorcycle is that he's going too fast. The speed limit was 45. And you're saying by the defendant's own testimony, the motorcycle driver was not speeding based on the fact that he said he was about a football field away and he waited 3 to 4 seconds. So you did the math and you come up with he must have been going 45 miles an hour. The way I do the math is if you cover 100 yards, a football field, in 45 seconds, you're doing 51.13 miles an hour. 4 seconds over 100 yards is 51, so that's a little over the speed limit. But the defendant said 3 or 4 seconds. So, I mean, look, nobody has a watch. He's just guesstimating 100 yards. Like, I'm not comfortable taking that as an established fact it was exactly 100 yards. He does. Oh, it looks like 100 yards. 3 to 4 seconds. Nobody in that situation really knows. But let's take him at his word. 3 seconds for 100 yards is 86.18 miles an hour. If you cover 100 yards in 3 seconds, again, the defendant said 3 to 4 seconds, he was 100 yards away, and then we crashed. So if it was 3, if we take the lower end, that means the motorcycle was going 68.18 miles an hour, which would be speeding, which would be comparative fault, would it not?
No, Justice Lindley, the expert came out clear. At 600 feet, at 3 to 4 seconds is 9 seconds at 45 miles per hour. At 300 feet, it's 4.5 seconds. But give it that. Say he's going 51 miles an hour. You look at all the Fourth Department decisions, it wasn't a substantial factor in causing the crash. Look at the cases he cites.
Now, you just used substantial factors, so that means you're already on question 4, which must assume that the decedent was negligent. You don't get to question 4 unless you assume that. I thought that your burden was first and foremost to prove that the decedent was not, as a matter of law, negligent.
Well, let's just take, if you're going to read the judge's decision earlier, you said that he skipped question 3. So let's give him the benefit of the doubt that he gave it negligence. And then find proximate cause. Go comparative. You have every Fourth Department decision, you have speeding, 5 to 10 miles an hour, and this court said, doesn't matter, no comparative fault.
So with specific to the facts of this case, if the court assumed that the decedent was speeding and that the decedent didn't react properly to the vehicle turning in front of him, reacted too late, didn't see it, was distracted, whatever, all the different reasons.
Which I don't know how, but I understand.
All the different reasons. You're saying none of that matters because a reasonable jury could not find that the speeding and the failure to react appropriately as a motorcyclist was a proximate cause of the accident.
Judge, I'm not saying that. This court has said it several times. But I just cannot wrap my head around the fact that you're putting this burden on a guy traveling. No, by the way, no evidence of speed. None. And you're saying this guy has, well, we're going to split hairs here. We're going to say, well, maybe he had 8 seconds to react. Maybe he had 4 seconds to react. He's on a motorcycle. Where does he go? If you ever ridden a motorcycle, where does he go?
But you say we're putting the burden on him. The summary judgment law puts the burden on the moving party, which is him. At trial, different burden. And look, your client's in a real, I mean, negligence is pretty obvious here. Proximate cause is obvious. It's just, is there going to be a trial on comparative or not, or do you just go for damages? That's really what we're talking about. You're making a lot of good issues, and you're very passionate and a great lawyer for your client. We have to take a look at all the arguments.
Thank you, Your Honor.
Thank you.
895 is Lance Wolfhanger versus, once again, Nut Butter Collective Incorporated.
Good afternoon, Your Honors.
Good morning.
May it please the Court, Robert Foltz, on behalf of the appellant, Lance Wolfhanger. The trial court improperly dismissed the plaintiff's claim under Labor Law 240, finding, quote, plaintiff's injuries were not caused by an elevation-related risk. The court, in the prior page, found, instead, air contaminated by noxious fumes falls beyond the purview of gravity-related hazards contemplated by this statute. Mr. Wolfhanger suffered a fractured skull and 2 fractured ribs. We didn't make a claim for a sore throat or sinus problems caused by the paint fumes, caused by the diesel fumes. We didn't make that claim. So it's very clear that the injuries suffered were caused by a fall from height. There's no question in the record. He was found unconscious on the ground, and the lift was 6 to 8 feet in the air. Now, the facts really aren't at issue. The interpretation of the law is. Now, in order to find that this is a breathing issue, you have to ignore that section of Labor Law 240 which says that the owners and the contractors are responsible to ensure that the proper device is there, and I'm not sure that a diesel lift inside is a proper device. And even if it is, and that lift was so placed and operated as to provide the protection to Mr. Wolfhanger. So what you don't see in the 18-page trial court decision is a discussion about, or an acknowledgement that, once again, not Butter or DeMarco were responsible to make sure that the lift was properly placed and operated to keep Mr. Wolfhanger from being overcome by the diesel fume and the paint fumes that caused him to have to stop working, start lowering his lift, and then fall from the lift.
Were there any other safety, I know you say that the diesel lift was improper because it was inside without the ventilation, but were there any other safety devices that were not provided to him that should have been, that might have prevented this?
Your Honor, it's not clear. The coworker, there were only 2 people on the site that evening because the fumes were so noxious. The coworker was using an electric lift. Could that lift have been appropriate for Mr. Wolfhanger? I don't know. No one said. There's some evidence in the record that that lift wasn't going to go high enough. Well, they could have rented a better lift, or they could have put up scaffolds, but they didn't. They said, use the...
Well, wait a second, Mr. Volz, under that scenario, forgive me for interrupting, don't lose your train of thought, but just saying they could have used a scaffold, I'm not sure you argued that, but put that aside.
No, we didn't.
Okay, but if they put a scaffold, the plaintiff still ends up in the same spot with the heat and the fumes. So you would say the scaffold was improperly placed, because your primary argument is that the boom was improperly placed in an area where there's the diesel fumes, the paint fumes, and the heat. So getting back to Justice Lindley's question, I'm not sure we have a case here involved in inadequate or absence of a safety device.
Well, Your Honor, the diesel fumes were caused by the lift. If it were just the paint fumes because they didn't provide Mr. Wolfhanger with a respirator, and the judges found that, as a matter of law, they did not do that. And if it were just those paint fumes, would he have gotten dizzy? Would he have fallen? I don't know. But we do know that it was the diesel fumes, and the only place those diesel fumes came from was that lift. Those diesel fumes and the paint fumes caused him to become disoriented, start lowering his lift, and apparently...
Mr. Gaylor, is that the expert Gaylor in this case?
That's correct.
All right. Okay.
And Mr. Gaylor, so, Your Honor, actually, to use your criteria, going through the step-by-step process, once again, Nutbutter and DeMarco were proper defendants. Wolfhanger was a proper and protected worker on that construction site. Wolfhanger became dizzy and fell due to these exposures. Wolfhanger fractured his skull and 2 ribs because of the fall.
He clearly has an injury caused by an elevation fall. I
Right.
get that.
So
what I'm stuck on a little bit is your proper placement argument. You might recall that in your brief you cited Wolf versus Ledcorp.
yes,
And in there, I cited about 20 of our cases, if you recall, on a concurrence, that talked about proper placement and replacement of it. But in Wolf versus Ledcorp, if you recall, it's where the plaintiff was moving his own scaffold, painting, moving it about, and it was a freshly poured concrete floor, and there were holes in the floor, and he pushed one of the wheels into that hole, and it tipped over. And there was an argument about, okay, there's placement, replacement. Does the owner or contractor have that duty? I questioned that, but we certainly have a lot of cases that seem to say it. But so that's the improper placement argument. What I'm stuck on is nothing tipped here, nothing fell, there's no evidence of improper placement unless you also include the respirator. And then if you need to include the respirator like you do in your brief, then is a respirator under 240 one of the other devices which shall be so constructed, placed, and operated? A lot of questions there, Mr. Volz, but my primary question is is the respirator a device required in this instance under 240 sub 1?
Okay, the respirator would not be present to keep him from falling, okay? The failure, the improper placement of the scaffold is, as far as the respirator, defense and the judge both kind of ignored the fact that there can be multiple proximate causes of an injury. I mean, a classic example is a ladder falls because the feet aren't appropriate, or fails because it wasn't designed to handle the weight it was handling. Now, those are very specific 241.6 industrial code violations. But the courts have always found that if you fall from a height, even if that fall was started because of an industrial code violation, the strict protections of the labor law for falls from height still apply. And Your Honor, I agree with your rationale in the Wolf v. Ledcor case. And actually the whole history set forth there is important and illuminating. This is a very similar case because it deals with placement and operation. There were no supervisors on site. It was too late. It was too noxious. A supervisor could have said, "Hey, Lance, get down. It looks like you're getting dizzy." Or, "Hey, Lance, take it easy. Lower your thing every 5 minutes because it's pretty nasty up there." A supervisor could have said, "Hey, Lance, why don't you put one of these fans in that electric boom lift or in that electrified boom lift?" There were no supervisors there, so it wasn't operated correctly.
If we took the fumes out of it, the paint and the diesel fumes.
He never would have fallen. We wouldn't be here.
But let's say we take out the fumes. You say he wouldn't have been dizzy, would have never fallen. But he's on a lift, right?
Yes.
And let's say he falls off the lift somehow. Absent sole proximate cause, that's still a 240 case because whatever safety devices were there didn't prevent him from falling.
That's correct.
So if he should win in that situation without the fumes, unless he just jumps off or he does something stupid or he's drunk, right?
That's
But
correct.
There are a lot of people who just fall off things without sole proximate cause. Maybe comparative negligence, but not sole proximate cause.
Right.
So if he wins without the fumes, your point is, my goodness, he should certainly win with the fumes when he has no respirator.
Well, that's exactly the case, Your Honor. The argument that counsel is making that says, hey, because there were fumes, it gives him less protections, is actually counterintuitive to the labor law. The labor law says, in faults from height, because these are such dangerous jobs, and that is such a dangerous position that people are being put in, they could even suffer brain injuries like Mr. Wolfhanger did, because these are such a dangerous type of occupation. The law must be broadly applied.
They shouldn't be rewarded for making it even more unsafe than it should have been.
That's correct. And that is what their argument is. Hey, something else can be blamed. That ignores the multiple proximate causes.
Your time is running short.
Okay. Just a few other things. Our expert, Ernie Gaylor, said, and he's the top expert in New York, I believe, said there's no question as to how this accident happened. There's no question that it became disoriented and that somehow or another he left the lift and fell 6 to 8 feet. That was never contradicted. Even if the judge were to find a question of fact as to, I'm not sure what, on the Labor Law 240 claim, there was no way she should have granted summary judgment to the defendants because they had no proof as to contradict the only uncontradicted proof in this record.
Thank you, counsel.
Thank you.
Good afternoon. May it please the court. There are really three issues in this case from the defense perspective. first and foremost, I think it goes without saying that fumes are not a height-related safety risk. Just like this court, the Court of Appeals found in Nicometti, ice was not a height-related safety risk. And we go through that analysis within our brief. So in the Nicometti case, there was ice, within in the facility. A man is on stilts performing work. He falls, obviously, from a height greater than where he would be on the ground. But the Court of Appeals says the ice itself doesn't present a gravity-related safety risk. That is a general worksite safety risk. Mr. Wolfhanger is complaining about noxious fumes. Those fumes are emanating from the diesel lift on the ground.
Counsel, if you wouldn't mind, and I don't mean to interrupt the flow that you have, but if you could jump to the Justice Presiding's point, you take the fumes out.
Sure.
Ignore it. It's a case where a person is going up in a boom lift with a lanyard and a harness. He's coming down the boom lift. For some reason, he falls out, perhaps partially because of his own negligence, but he falls 8 feet and cracks his skull. Why is that not a 240?
Well, it's not 240 because the plaintiff still has to establish that he fell as the result of not being provisioned the proper safety devices. Those safety devices didn't operate properly. He wasn't properly trained. In this case, what we have is an unquestionably safe work platform. No evidence whatsoever that the platform itself was defective. No evidence that the rails were bent or broken. No evidence that the door didn't close properly or any of the other safety devices of the boom lift itself were problematic, okay? So...
Well, they would say, if that's the case, he wouldn't have fallen.
Well, the problem is here, Your Honors, what we have is we have a plaintiff. They're saying he's disoriented by fumes. Yet he still had the mental wherewithal to operate a lift, which has 2 different safety switches, lower it. He told us in his own testimony, which is unquestioned, that he always uses the harness. It's automatic. It goes on as soon as I get in the lift. So he obviously, therefore, unclipped himself from that harness. So he was able to operate the lift, lower it down, find his lanyard, unclip it, and then potentially utilize the door to open it or somehow fall out. But if he physically unclipped himself from the safety line and harness, and not only did he testify that he was wearing it, he was found wearing it. He had all the necessary appropriate safety gear. If he remains clipped in, he doesn't fall. It's that simple. There's no evidence that the harness or the lanyard failed. There's no evidence that the boom lift failed. There's no evidence that the safety rails failed. It doesn't exist. We don't even know how he fell. I don't know if he jumped. Plaintiff seems absolutely convinced that, there is no evidence that there's any other way that this man fell out of this lift than he fell. We do know that he smokes 2 packs of cigarettes a day for 30 years. We do know that he has underlying health conditions. But apparently Mr. Gaylor, the professional engineer, is now also a physician, and he's going to tell us that the plaintiff had certain, physical effects as a result of these fumes. Mr. Gaylor, of course, doesn't have that. I mean, those are trial issues. But here what we have is fumes, which are a general worksite safety risk. We have the plaintiff being provisioned with all of the necessary safety devices for a gravity-related risk. And the plaintiff is simply trying to shoehorn a 241.6/200 claim into 240. Do I agree that there are questions of fact at this point with respect to the industrial code and so on and so forth? Sure, and we're going to try those issues. But with respect to the strict and absolute liability, I just don't see it.
Thank you, Counsel.
Thank you, Your Honors.
We're going to call the case out of order. We're going to go to 897, Kessel versus Holtz. The Capizzi, Brown, Chiari case is going to be argued next, after this one.
Good afternoon, Counsel. May it please the Court. Sarah Coco for Appellant, the Attorney General. Article 63A allows New York courts to issue extreme risk protection orders, and the Supreme Court here erred in declaring Article 63A inconsistent with due process. First of all, the law does not burden a respondent's Second Amendment rights.
Before we get to that, the problem here is that your office wasn't notified and wasn't able to be heard.
It is correct that our office was not notified, yes.
And so why wouldn't we remit it and give you a chance to be heard and then see what happens from there? Maybe you'll win. Maybe you'll convince Judge Reed.
So the court could do so, Your Honor, but we urge the court not to do so in this case, and the court would be within its authority not to do so. That's the Matter of Markham case that we have cited in our
Yeah,
brief.
no, I did see that, but look, you're here alone now. He was here alone then. Like, why don't we get you in the room together and you can both be heard, and then whichever judge decides it can have the benefit of both arguments.
So, Your Honor, the respondent obviously was served with notice of this appeal and had the opportunity to appear, and so we don't think the fact that he has chosen not to pursue this appeal should prevent the court from deciding the issue. And let me just say why we think this is an urgent issue that this court should address on the merits.
Before you get there.
Sure.
Have you found a case, and maybe I missed it, where in this situation, after the amendments to the CPLR, which requires with no uncertain terms that notice be given, have you found a case where the court didn't remit and went to, because Markham predates the amendments, have you found a case where the court didn't remit? Looks to me like, I'm sure we have discretion because we're judges, et cetera, but it looks to me like every case I have found anyway says that we're supposed to send it back so both sides can be heard, following up on the Justice Presiding's comment all at one time. Have you found a case that says otherwise since the amendments?
I don't have a case that says specifically that, but this court would clearly be within its authority to address the constitutional issue. There is no statutory bar to addressing the constitutional issue because the Attorney General has appeared to address the issue on the merits. So there's no statutory bar here under Executive Law 71 or anything else that would prevent this court from addressing the merits. And here we
did the court of first instance in that regard if we were to decide the constitutional issue, right? We would no longer be an intermediate appellate court. We would be the court of first instance.
Well, I would disagree, Your Honor, because the problem is, and let me get back to why we're asking this court for this in this unusual procedural posture. So Supreme Court here did declare this law unconstitutional, and so it's not functioning right now as it's intended to function, which is a tool to protect public safety and prevent gun violence. So the fact that Supreme Court declared it unconstitutional is also creating confusion for potential petitioners for IRPOs, which right now cannot seek IRPOs in this court. And for example, law enforcement officers are mandatory petitioners under certain circumstances. So do they go to court right now knowing that a court has declared the law unconstitutional, or did they?
This all stemmed from Justice Moran's decision, because it sounded like Judge Reed just relied on Tom Moran's decision, Judge Thomas Moran. Was that appealed? What's the status of the Moran order? Because he declared it unconstitutional for these same reasons.
You're correct, Your Honor, and that case was not appealed. The Attorney General was notified. At the time that that decision was issued, it was an outlier, and we did not, anticipate that other courts would adopt this erroneous reasoning.
Well, a lot of them haven't. A lot have ignored it.
That's correct, Your Honor. A lot have ignored it, but several now have adopted this
Right.
reasoning, and so we're concerned that it's creating active confusion and preventing the law from functioning. I would also just add that the Justice Moran decision that you're referring to had several factual differences with this decision. So that here we have a law enforcement officer who was directly involved in a conflict with the respondent. There, I believe it was an estranged family member,
Right.
and the judge also noted that many of the statements in the record there were more than 6 months old. So there was these other reasons that an IRPO or
I got
TRPO
you.
may
You
not
might
have
have
been appropriate.
ultimately lost on the merits there, but we're going to have to remit, even if we were to entertain the merits of your argument and agree with you that the statute's constitutional, we still have to remit it.
That's correct, Your Honor.
Then
So
there'd be a hearing to decide whether this gentleman's gun should be taken from him under the statute.
That's precisely the relief we're seeking. So we're not asking this court to make any type of factual determination here about whether an IRPO should be issued. We're simply asking this court to clarify that the law does provide due process. That's really the key issue that's creating this active danger to public safety that we ask the court to address today.
And trust me, on the merits, we've all read the brief and we understand your criticisms of the Justice Moran decision, the need for medical examination, and you go through that at length in the brief. Do you wish to be heard quite briefly on that now, or are you comfortable resting on your brief?
Let me just briefly address the merits of the issue, because we do think that this is extremely important and also clear. So it's extremely clear that the text of the statute does not require a finding of mental illness or an examination by a physician. That's not present in the text of the statute. And likewise, due process does not require that in these circumstances. And this is different than in the mental hygiene law section 9.39 context, which has to do with involuntary commitment, because the Supreme Court has said that for involuntary commitment to be constitutional, there must be a finding of both mental illness and dangerousness. And in the Second Amendment context, by contrast, there's ample support for disarming an individual based solely on dangerousness. So
Right.
there's this key difference.
The point that you're making is that you can be dangerous, somebody can be dangerous without being mentally ill.
That's correct.
they're not, they don't, sometimes they overlap. But in the mental hygiene, you are depriving somebody of liberty because they have mental illness, so it makes sense, like, we want to make sure they're mentally ill.
Correct, Your Honor.
This is totally different. You can have, again, bail states all over the country have dangerousness standards to hold people, take their liberty from them on a dangerousness standard without any evidence of mental illness, without any examination. And if Justice Miranda is right, then all those bail laws are unconstitutional.
That's correct, Your Honor. So we do think that it's clear that no mental illness or physician's examination is required. And here, Supreme Court declared the law unconstitutional in reasoning that would apply to other cases and said that you would, in every case, you would need a physician's examination. And just very briefly, on the state's interest in not having these types of additional procedures required, the decision here is actively preventing certain petitioners from seeking IRPOs because those petitioners would not be able to compel a medical examination. For example, you have family members or school administrators. The legislature thought that it was particularly important that family members be able to seek these extreme risk protection orders because family members are often the first to see that someone is exhibiting signs of dangerousness. So if you require them to go and get this compelled medical examination before they can go into court and seek a TURPO, that's going to prevent them from seeking those TURPOs and prevent the law from functioning as it's intended to as this important tool for public safety.
All right. We understand. You want this decision off the books as soon as humanly possible.
That's correct, Your Honor. If I could just add one more point, I would refer the court also to the district attorney's amicus brief explaining how this law is currently being used in New York by law enforcement to seek these as a tool of law enforcement. So this is an immediate public safety issue.
Thank you.
Thank you.
We are going to take a 30-second recess. We have some recusals, so we're going to rearrange the bench, and then we're going to be calling 896 Capizzi versus Brown Chiari. Justice Curran and Justice Ogden have recused on this case. We have another judge coming in momentarily. Do you need us to switch seats? Okay. All right. Good afternoon. Thank you for your patience.
Good afternoon, Your Honors. May it please the Court. Justice Montour-Noack, it's a pleasure to see you on the appellate bench. Your Honors, in paragraph 10 of Mr. Capizzi's amended complaint, page 49 of the record, he alleged that there was an agreement between and among the four individuals and then later the three individuals that made up the Brown Chiari law firm. We asked him in the course of the proceedings in this case, we asked him in interrogatories and pleadings and submissions, the discovery, the testimony, deposition testimony, trial testimony, what were the parameters of that agreement? And he basically told us there were three things. One, that he was a 20% equity owner of the firm. Two, that he was entitled to 20% of the net distributable income of the partnership. And three, he told us, in his own words, that there was an agreement with respect to departure, that if he left, he could take with him his files, but any files that remained at the firm he would not have a claim on. Importantly, when he laid out those three aspects of the agreement between the parties, he did not say he was entitled to the defaults under the partnership law of New York State, that he was entitled to 33 1/3% of the firm, that he was entitled to 33 1/3% of the income, or any of those other things. We denied that he was an equity partner of the firm, and Judge Walker ruled against us, and this court, including Judge Lindley, you were on that panel, ruled in favor of Mr. Capizzi, said he was an equity partner. And Judge Walker had phased the case. Phase one was, is he an equity partner? That was decided. We went to phase two. What are the parameters of the agreements that govern that partnership? We rely here today on Mr. Capizzi's words, which he has now, that he has the Fourth Department's decision in hand and Judge Walker's decision in hand, almost completely repudiated. He says no longer is he a 20% equity owner of the firm, but indeed he is a 33 1/3. He says there was no agreement, there was never an intent, there was never a meeting of the minds, completely contradicting his prior record before this court. He then says, although Judge Walker found that he was bound by the 20% NDI agreement and a subsequent agreement in 2014 that Judge Walker found that he had agreed to and was bound to between the three individuals, that he was entitled to a full 20% of the net distributable income even in 2014 when he accepted 14% of the NDI in the form of a bonus check and made no objection to it, and in 2015 when he accepted 11% and made no objection to it. He also, and most importantly for this appeal, Your Honors, he repudiates what he previously testified to multiple times, that there was an agreement in place between and among these three partners that if any of them left the firm, they could take with them the files that they had originated, but they would not have a claim on files remaining at the firm. They would not hurt the law firm on their way out the door.
Right, now, he's obviously taking a different position now, but could it be that his explanation is, well, we had Judge Fahey's decision, and I was educated. He's evolved in his position, and now that he does believe he has an interest. I mean, everyone agrees he could take the files that he originated, but now he wants what's left. He wants a percentage of that, and he's learned from the previous litigation.
Well, Judge, that featured in the first appeal, no question about it. But here what's important is, after Judge Fahey's decision came down, Mr. Capizzi said he read the decision several times, a number of times. He's very clear in his testimony. And he said, I'm situated the same way. I'm an equity partner. And Judge Fahey had said that Frank Frascogna was an equity partner. 5 months after that decision came out, Mr. Capizzi filed papers with Judge Curran, and I wondered whether he might recuse himself, and he did, wherein he said, the deal was, I understand that Mr. Frascogna is an equity partner now. I understand that Judge Fahey made himself an equity partner and made me an equity partner. But the deal is, and the deal always has been, that you can take your files, Mr. Frascogna, and you do not have a claim on the files that remain at the firm. And that benefited Mr. Capizzi. Why? Because he remained a partner of the firm. When Mr. Frascogna walked away and left his files behind, that benefited Mr. Capizzi. And it also benefited him to oppose Mr. Frascogna's claim that he had a claim on all of the files that remained at the firm. And that was the exact posture in the Frank Frascogna litigation that we find ourselves in now. He is now saying, after repeatedly testifying, that that was the deal, it remained the deal, we changed nothing, it continued to be the deal. He testified about that in 2005, 2006. He filed some papers with Judge Curran in 2007. His attorney filed those papers on his behalf with his knowledge, saying that was the deal. He acknowledged the deal again in his testimony after his departure from the firm, both in deposition and at trial. And now he says, oh, that was not the deal. That doesn't apply to me. There was no meeting the minds. I didn't really mean that. Your Honors, Mr. Capizzi is an officer of the court. He used the deal, his term, the deal, to try to defeat the claims of Frank Frascogna, whom he knew was an equity partner at that time, at a time when he knew he was an equity partner.
This is like judicial estoppel in effect.
Judge, it's a judicial admission, and it's also testimony that describes the agreement of the parties. And again, these agreements, the court in the prior decision, there's no question, we've all read it, said that Mr. Brown and Mr. Chiari could have, coming out of the Frank Frascogna litigation, written down, had come up with a partnership agreement. I mean, I think it's fair to say that this panel, and perhaps Judge Walker too, faulted those two individuals for not writing things down in a partnership agreement. And perhaps that fault is warranted. But what they did do, according to Mr. Capizzi's own testimony, and we're relying in this appeal 90% on his testimony. Mr. Chiari and Mr. Brown said it too. But Mr. Capizzi said there were 3 agreements. One governed his ownership interest, 20%, not 33 1/3. The other governed his compensation, 20%, and then reduced in 14 and 15 pursuant to an agreement that Judge Walker said he made, a revision to the 20% NDI agreement, and an agreement, most importantly for this appeal, that you will not take any files with you beyond those that you originated, and you will not have a claim on the files you remain behind. And the reason I emphasize that is because if you think about what are the principal terms, if we're talking about Contracts 101, what are the necessary terms to this agreement? The necessary terms would be, how much of the firm do you own? Agreed to. How are you getting paid? Agreed to. What is going to happen when you depart? Agreed to. The main terms, even though they were never ensconced in a partnership agreement, were agreed to between and among these individuals, and Mr. Capizzi testified to that. Now, not for nothing, I do want to make the point that in addition to what Mr. Capizzi said, Mr. Brown and Mr. Chiari also testified to the same thing. And I found throughout the records in this case, their testimony agreeing with Mr. Capizzi, confirming that those were the arrangements and those are the deals, has been discounted as if they're not really parties here, as if the
pattern jury instruction charge that says that they're interested witnesses and the jury could disregard or give little weight to their testimony if it wished to, had already been a done deal. I disagree that that should have happened here. Not only did Mr. Capizzi testify that the deal was if he departed the firm, he could take his files and he would have no claim on the files that remained. Mr. Chiari and Mr. Brown, also officers of the court, testified to the same thing. And another point that's important, Your Honors, why would they make that deal? Why would they make that deal? This is Mr. Brown's firm. He started it in 1973. He's still practicing law. It is a 50-year-old firm. All along, at every stage, Mr. Capizzi acknowledged from the time he joined the firm in 1989 until the time he departed in 2016, the deal was you can always leave and you can always take your files with you, but you cannot hurt the firm as you go out the door. And that is what the court in the Dwyer case said was exactly what parties can agree to when they form a partnership, that you will not necessarily get a claim as part of your equity claim. Now, he gets the default partnership rules with respect to the firm's bank accounts, what was in the bank accounts, his capital account, the plant and equipment, the desks, the computers. Nobody's disputing that those things were not agreed to. But what was agreed to for the purposes of this appeal was you cannot hurt the firm as you go out the door. Mr. Capizzi testified to that. Mr. Brown testified to that. Every single person in this case, every party testified to it. Well, what do we hear from Mr. Capizzi now that he's won on the issue of whether he's an equity partner? Oh, well, no, there was no meeting of the minds. That really wasn't the deal. Oh, when I said that that was the deal relative to Frank Frasconia to stop him from claiming the files, I didn't really mean it. I knew he was an equity partner then, and I knew I was an equity partner too because I'd read Judge Fahey's decision. But it was okay for me to say that down and then and make representations to the court, judicial admissions. And it was okay for me to give that testimony. I questioned him in his deposition. I cross-examined him at trial. Every single time he agreed that was the deal. You will have no claim on your files.
We understand. You made that point. Anything further before we give opposing counsel a chance to respond?
Your Honor, I think I will rest at that point. Thank you very much.
Good afternoon.
Good afternoon, may it please the court. Your Honors, all of the testimony that was just referenced there, the so-called deal, the so-called understanding, all of that is based upon testimony at a prior law firm, at a prior case, and a prior partnership. That testimony did not occur in this case. Although Mr. Capizzi was asked questions about that testimony, it is very, very clear that the record in this case, Mr. Capizzi indicated that was an understanding when I believed I was a non-equity partner. In fact, this court's decision, the decision, or rather memorandum in order entered on May 7, 2021, specifically indicates that Mr. Capizzi and Mr. Chiari were both testifying when they considered themselves not to be partners in that firm. So think about it this way. The core of their argument here, the core of their agreement involves testimony from a prior partnership. But everybody admits they were both testifying with respect to what are the rights of an employee, of a non-equity partner. They were both testifying in that regard. So if they're both testifying in that regard, what are they talking about? They were talking about an understanding, and the understanding that they were talking about is basically the common law rights of what you can do as an attorney when you leave a law firm, when you leave a personal injury law firm. What can you do? You can ask your clients to come with you. And if they agree, you can take those clients with you. Mr. Chiari at page 1043 of the record testified in this case that when Mr. Capizzi was testifying on that issue, it was under his belief that he was a non-equity partner. That's a significant distinction. Counsel discussed what I call the Mucklewee submission. So the Mucklewee submission comes after the Frasconia firm is dissolved. There's a motion to compel, a motion for an undertaking. The Mucklewee submission very specifically indicates that Mucklewee is talking about a position that was taken. The position that was taken by Chiari and Capizzi with respect to the rights of a non-equity partner. That's the linchpin here. In addition, those motions were never ruled upon. That particular issue was not teed up for the court to decide, and that prior court never decided that issue. Capizzi, Mr. Capizzi, also testified in this case, he never even reviewed those papers. Ultimately, we need to take a step back because all of the defendants, all of the parties in this case very specifically acknowledge once we get to BC LLP, the law firm, the partnership that is at issue in this case, we don't have any discussions about dissolution agreements. And by the way, an agreement to be a partner, to be in a partnership, is significantly different than an agreement that governs what happens when that partnership breaks up, what happens when there's dissolution. This court, in its prior decision, determined partnership based upon a multi-factor test. Whether or not you have a dissolution agreement is a completely different test. That's basic contract tenets. And in this case, we're missing that. Specifically refer the court to the Congo case, which is the Court of Appeals decision about whose burden is this? It is the defendant's burden to demonstrate that there was a departure from the default rules of the partnership law. And they must demonstrate that the language of the so-called agreement is clear, unequivocal, and unambiguous. In this case, they can't meet any of those terms here. They can't meet that test. The trial court specifically recognized that, well, the defendants failed to explain the precise terms of this so-called agreement, failed to show when the agreement was made, a precise date or even a year, identify who the actual parties were to the agreement at the time, and dispute the testimony that none of the four partners in the prior firm ever specifically discussed the agreement amongst us. That's exactly what Mr. Capizzi said. We actually didn't talk about that among the four of us. And then when he was asked questions about, well, what would happen to the files that Don had and Jim had, Mr. Brown, Mr. Chiari, at that Frascogna trial, he said, I have no idea what would happen to those files. Not only is the agreement incomplete, but it's changed. First it was an express agreement, now it's an oral agreement. The alleged agreement also fails to account for probably what is one of the most significant things here. These folks, when they were three equity partners together, spent a whole heck of a lot of money on advertising. And because they spent all that money on advertising, they jointly originated 1,000+ cases together. This so-called agreement doesn't tell us what happens to any of those jointly originated files. So it's incomplete, it's indefinite. So where does this leave us? What it really does is it leaves us without a dissolution agreement. We've already decided there's a partnership, but we have to decide, was there a dissolution agreement of what will happen when the partners depart? In this case, we're left without that dissolution agreement. Now, I want to be absolutely clear because there is no doubt that Mr. Capizzi came in and stated in several areas and produced many records of evidence demonstrating he was at least a 20% owner. He stands by that, he said it, the records say it, there's no doubt that's true. But if the question is different, if the question is, well, was there a dissolution agreement? Was there an agreement to depart from the default rules of the partnership law? Defendants say there was no partnership. Well, if they say there's no partnership, how can they say, but if there was a partnership agreement, well, then we had a dissolution agreement? They actually never say that. And because they never say that, the default rules of the partnership law apply. Section 40, the partners share equally. It's as simple as that.
All right, you should begin to sum up if you have anything further. Thank
Not
you.
unless there's any questions, Your Honor.
Thank you, Counsel.
Thank you.
Case 898, Rimkus versus Rogers. As you see we have some recusals here. Justice Montour and Justice
It's an
Noel.
entirely different panel, Your Honors. Good afternoon, my name is Peter A. Reese, I'm here for Melanie Rimkus, and I apologize, this is allergy season for me, so it's froggy time. Basically, I'd like to say we like elections and we'd like to have one. We're here because of Article 16, it's the only reason the courts can hear these. And in particular, we are interested in a delightful reform, which is part of the new 16-154, the election law. I've had experience with the problems that arise before this occurred, and it's a wonderful thing to have.
Right, so your argument here is that under 6-154-3, they needed to identify the volume number here
That's
for
correct,
their
Your Honor.
objections, and they didn't put a volume number, but they say on the other hand, well, there's only one volume, so what are we going to do here? They did put the page, or pages and so forth, but they say it's a little different when there's just one volume as opposed to multi-volumes. There could be no room for disagreement as to what volume it is, no room for confusion. How do you respond to that?
Your Honor, we comply with the election law even when it doesn't make sense. And this is a substantial compliance statute, all right? If somewhere in their objection they had said the petition consists of one volume, we would have, and all the objections that below refer to that, we would have said, fine, that's substantial objection. We wouldn't be here. The word volume isn't even in the objection. I mean, you can word scan it. It's not there at all. There are many times when we have to comply with things that are in the election law, even though they don't seem to make a lot of sense. And I can tick off a few, but for instance, a few years ago, I took a CLE course from then Commissioner Dennis Ward, who is now a judge. And I was representing a union which had a political action committee. They were limited in how much money they could give to a candidate, even though they had an abundance of wealth in it. At the CLE, I asked Mr. Ward, I said, well, why couldn't this union divide up their membership into two packs from A to Z, or A to M and N to Z, and have two packs and then be able to double their contributions? And he said that would be okay. I said, does that make any sense? And his response was, who said the election law has to make sense? I mean, the law is there, it says what it says.
Right.
It would have been no problem for them to put volume
Strict
down.
compliance, even if it wouldn't make a difference below. You don't challenge, you don't contest any of the signatures that were struck.
We never bothered to contest that, Your Honor, because our position is there's no objection here. There has to be a valid objection for you to get to the point where you look at the line by lines on the signatures. There are other cases, I think Stoppenbach is right on point, even though that's disputed. That's a substantial compliance law. It's still around after 21 years, and it says you have to have town or city at the top of the petition. If you've ever had any experience cleaning petitions in Western New York, the number of times that we have to cross out Williamsville and put in Amherst, or Kenmore and put in Teton, or Sloan and put in Cheektowaga. Sloan, I petitioned in myself. The people in Sloan don't want to live in Cheektowaga, and you have to fight with them not to write Sloan in for town, and those signatures are no good. The courts are requiring essentially strict compliance with that, and in Stoppenbach, what they said basically is if people don't like this, it's for the legislature to change it. I see very little difference between this and that, and the legislature has not seen fit to change it.
The word volume, they put it in there for a reason. It wasn't used here, and you think
That's
therefore the
correct, Your Honor.
objections. We understand.
And there's another point here with respect to this. The Rimkus petition is there, and you can see the cover sheet of that volume, or on that petition. It's 27 pages long. She made a mistake. She thought that she should put the number of pages. It's a 27-page petition, and so she had the volume number as 27. She was called in and required under the 3-day rule to change that to volume 1. Now, I think I could probably argue that I can call my only volume, volume 27, but that probably would lead to, and she did, and you can see it on there, and she initialed it. If a volume was that important for a cover sheet, which quite frankly does not have all that much value, I mean, the petitions were circulated to the voters. What matters is that were there sufficient number of signatures valid gotten by the voters. The cover sheet is so much surplusage. But she would have been, the Board of Elections would have thrown her off if she had not corrected that cover sheet. Another example I can give you that I had some experience in, about 10 years ago, there was a big effort to overturn or take over the county committee in Niagara County. There were hundreds of petitions filed for committeemen. Now, if you don't have 10 pages in your petition, you don't need a cover sheet. Literally hundreds of petitions were submitted with a defective cover sheet. Those petitions were all thrown out because when the people were contacted, they did not correct the defects in their cover sheet. So hundreds of people were thrown off the ballot to run for committeemen that year for defective cover sheets that weren't even required to be on the petition in the first place. We have to, if we put a cover sheet on a petition, even when it is not required, the petition is thrown out.
I understand.
That's compliance with the law. I mean, I'm standing here talking about black letter law and facts, and quite frankly, I'm rarely in a position to be able to argue that to the court. And to say that this is irrelevant, that the law is irrelevant, essentially means it doesn't make sense. Often the election law doesn't make sense, we comply with it. And it's for the legislature and not the courts to change the provisions of Article 16.
Thank you very much.
Thank you.
Yes. Mr. Toth.
Your Honors, thank you. Jeremy Toth, Erie County Board of Elections. The legal issue is pretty straightforward. Justice Lindley, you accurately described it. The only thing I would add is just the practicality. The calendar right now, early voting begins on Saturday. Ballots have already been returned, opened, will be scanned on Friday. I would suggest, and I put it in my papers, that the delay in perfecting this appeal should prevent the relief being sought.
The decision was made in August?
Mid-August was the order.
Mid-August.
Notice of appeal, I believe, was the end of August.
And now here we are 2 days before.
Early voting begins on Saturday. The absentee ballots that have been returned have been opened pursuant to new statutory guidelines. They don't get scanned until Friday, but on Friday.
Even if we agreed with him on the merits,
I'm not sure exactly.
There's some latches, some delay here that it's just not practical. I mean, he didn't really explain what the purpose of the delay was or the reason for it, but we'll take a look at that.
Thank you, Your Honor.
Yeah. Thank you.
Sorry.